It's a batch of matter where the extension of the validity, extension of the period for assessment has been challenged, that notification. My item has been tagged here. It was in the, yesterday it was on your lordship's board, fresh matter. It is tagged without any interim protection. So your lordship has brought this matter to fix up a date for hearing. I pray before raising this matter, my matter may be taken up so that I can get the interim protection. The similar orders which has been passed in the other matters.
Who is for the other side?
And at the Central Government Council and State Government tax as well as. And it is only for
the matter shall be called at 4:30, 4:25?
Yes, ma'am. A deeply blessed.
4:25.
May I make a mention?
69.
May I make a mention, my lord? No, it's an urgent matter, passport matter. That's why I'm here mentioning it here. My lords, the passport of the petitioner's son is pending in the
You
past.
must have filed writ petition.
Yes, my lord, I have filed, but I have got only the diary number. The SR has not been done till date, and it is very urgent because the passport.
Stamp reporting expedite.
Yes,
This is the only thing which we can do. Your stamp reporting shall be expedited.
yes,
So-
your lordship, because on first
All
of
right, all right.
obliged, highly obliged.
Let's see, if I may pardon to mention, my lord, it is a matter pertaining to the elephant corridor. My lord have pains of lord on this matter. Because of this elephant movement, lordship, in Khordha and Noyagarh range, the Robbie crops have been severely damaged. Lordship may taken up next week on Monday.
So what order the court should pass?
Lordship, our prayer is that there was a joint inspection of both Forest Department and also the Revenue Department pertaining to digging a canal at Ronda Minor Irrigation Project. It is in Noyagarh district, Khordha and Noyagarh border, lordship. Because of that, the farmers are facing severe difficulties for keeping
When is that matter?
Lordship, pray for next week. Lordship, have heard this matter, my Lord Justice Raman, on division bench.
Maybe permitted to mention, my lord. This writ appeal is challenging the honorable single bench matter relating to eviction. The honorable single bench had protected us for a month. The order was on 31/1/2024. It has the 1 month has already elapsed. I just pray for it. I pray that it may be taken urgently.
No, this is a writ appeal.
Yes, ma'am.
I may be pardoned to mention, lordship, in this the petitioner has challenged the inaction of the opposite parties for serving multiple show cause notices for and disturbing the commercial use of the property. And this matter was solely heard by Honorable Justice R.K. Patnaik, but currently the bench is not in session. So, your lordship.
Just give your slip to the registrar, deputy registrar judicial. He will ensure that the matter is.
Press admission item number 1.
May it please, ma'am. It's a writ appeal, my lord, against the order of the learned single judge. My lord, the facts of this case is this. My lord, way back in 95, there was an advertisement for appointment of dumper and dozers drivers, my lord. And the minimum qualification was 3 years, my lord, which was prescribed under the note advertisement. And my case was not, the petitioner's case was not considered as they found that there was no experience of 3 years that was mentioned in the advertisement, my lord. And I challenged it in the year 2001, saying that we had the requisite qualification of 3 years. And after that, my lord, learned single judge has dismissed this case on the basis of Section 4 of MB Act, saying that even though you had the experience, but under the MB Act 4, you are restricted because 20 years is the minimum age for which you have to need to, for the heavy vehicles, 20 years is the age limit. And after that, you, by the time the advertisement was issued, you are not having the 20 years experience. Even though by the time my lord advertisement was issued, I was more than 20 years, but they say that when you are 20 years, that time these experience certificates belong to a period when you are not 20 years, my lord. But my lord, in the rejection
Reasoning is
order,
absolutely correct.
my lord,
The reasoning which has been assigned by the learned single
My
judge is absolutely correct.
my lord, section 18 of MB Act says if the vehicles are of the central government, then the age limit will come down to 18 years. Now, my lord, question is this, my lord. Now, what has happened meantime, my lord, there was an order passed on
Sir,
on
Council,
My lord.
the learned single judge has referred to section 4(2) of the Motor Vehicles Act.
yes, my lord.
Which
It-
prescribes that no person under the age of 20 years shall drive a transport vehicle.
Yes, ma'am. Yes, my lord. Very well.
So for this, you were required to be having experience of 3 years.
3 years.
So since you were below 23 years, your case has not been considered.
My lord, I was having the 3 years experience was there.
3 years experience wrongly. How could you acquire 3 years
My
experience?
lord, 3 years experience was there when I was in from 1888 till 90. That experience I was having. 3 years experience was there, my lord. But the problem is that when I was 20 years, after 20 years, they say that after 20 years, I was 20 years way back in 91, my lord. I filed a case in 2001. By that time, I was 31. When the advertisement was issued, I was 25, 26. But they say that when you were 20 years by the year 91, you have given an experience certificate prior to that period. So that is the reason, my lord, that is the reason that after 20 years, I don't have the certificates, my lord. Now, case is this, my lord.
And
The rejection order.
What is your age now?
Age is now, my lord, more than 50 years. More than 50 years. My lord, for
More
that
than
reason,
50
my
years.
lord.
More than 55 years, it must be more than 55 years.
No, my lord. When those writ applications were filed, my lord, in 2001,
Unnecessary.
my lord, may see order dated
No,
of 21st November 2022.
sorry.
My lord, may see for a moment, my lord, may see that 21st November 2022 order. There are still vacancies, my lord. My lord, kindly see, my lord, 21st November, this order dated, my lord,
We are not satisfied.
5/9/22, my lord. My lord, kindly have a glance on that.
Nothing
order.
can be done now.
My lord, there are vacancy positions, my lord. There are vacant positions still now, my lord. We have filed affidavit to that extent that there are vacant positions.
What is your age?
My age is now, my lord, I'm just. My lord, at that time it was 31 years, way back in 2001. It is now, my lord, near about 55 years. Some are like 53, 55 years. So, my lord, near about 55 years.
The appellant in the present court, intra-court appeal.
Can I
Yes.
say something more, my lord? Just one more submission I have. My lord, in the rejection order, what they have done, my lord, in the rejection order, they have never mentioned that you are barred by section 4, my lord. What has happened in rejection order, they say that you don't have a 3 years experience. But actually by that period, my lord, when the employment exchange, I was sponsored by employment exchange, and employment exchange sponsored me because I was having 3 years experience. So, but they say that you don't have a 3 years experience. Now, my lord, the case has been taken a different turn. It says that by section 4, you are being barred. But my lord, section 4, if it will be at all pressed, it was pressed into contention, my lord, in 2014, my lord, when this single judge order was passed, my lord. By that time, my lord, I had all the requisite experience. By this period, my lord, I have all the requisite experience, my lord. So, my lord, I pray that if today, if the vacancies are available, so why I will not be allowed to be absorbed in those vacancies, my lord? Because only that period of 3 years, was was a period, my lord, because by that time when I was having this 3 years experience, I was not 20 years. But when the notifications came, my lord, when the advertisement came, my lord, by that time I was more than 25 years old. So, my lord, when they rejected, they said that it is not 3 years. But by that time, even though, my lord, I was 25 years, I was having a 3 years experience, my lord. And my lord, 2014, when ultimately the writ was dismissed, by that time, my lord, all this experience I was having, my lord, but only for that you are not 20 years when these experience certificates were put on record. When Employment Exchange sponsored your candidature, my lord, that time I was not having that. I was not 20 years by that time. They say that. But when notification came out, I was very well within the compass of more than 20 years, my lord. So, my lord, I request, my lord, submit that, let them be absorbed, my lord. Even if posts are available, I have filed affidavit, my lord, to that extent. My lord, may I see flag A, my lord? There, my lord, I am giving the existing strength. Sanction strength is, my lord, 174. Existing strength as on 1922, my lord, is 46. There is a shortfall of 128. In regard to dumper, my lord, it is 251 and existing strength is 82 and 169 as on 19/2022, my lord. So there are vacancies available, my lord. If, my lord, they can absorb me, my lord. That's it.
Do we have permission to
Sorry, my lord. I never intended.
dismiss? Never. You may lose a case.
My lord,
but
sorry,
never
my lord.
lose-
Sorry, my lord.
Lose the
No,
court.
my lord, that was never my intention.
This was, yes.
Sorry, I am extremely sorry.
Item number 2.
Please, Your Lordship. Pursuant to my lord's direction, I have filed affidavit enclosing the appointment and approval of the governing body appointing the deceased employee as a lecturer in post of Odia, that is flag X, my lord. My lord, the deceased employee, the appellant expert during the pendency and subsequently substituted by legal heirs, my lord. The deceased employee had passed MA in Odia by place, my lord.
Yes, yes.
Deceased employee had passed MA in
This is
Odia.
your first appointment letter, the appointment letter of your mother.
My lord,
This is the appointment letter. You are the legal heir.
legal husband and petitioner daughters, my lord.
Yes.
Daughters and
So this is the appointment letter of your wife.
flag,
The
my
deceased
lord,
wife.
flag X to my affidavit.
This is 27/2/1986.
My lord. Thereafter, governing body approved in the next page, my lord.
Yes.
My lord. Communication made by the secretary of the college.
Yes.
My lord. The deceased employee, before her appointment, had passed MA in Odia by securing 63% of marks in PG examination and has also done MPhil degree before appointment. And after appointment, she had awarded PhD degree. Your Lordship kindly see the government resolution regarding appointment relating to qualification for appointment of a lecturer in a college. Your Lordship kindly see annexure. Six at page 53. May I permitted to read? I am directed to say that government, after careful consideration,
Do you have any reply to the delay?
delay, ma'am. Yes, ma'am. In Mamata Mahathi case that has been explained by the Honorable Apex Court, that petitioner after 15-20 years filed a writ application before this Honorable Court. And in Mamata Mahathi case, all those points raised by the state, including delay, was considered and directed the state government in Mamata Mahathi case to examine individual cases and extend UGC scale of pay to teachers, those who have acquired PhD and MPhil degree from the date of acquisition. And government, ignoring the delay, everything, because direction was there to examine each of individual case and extend UGC scale of pay. Government extended all of them.
Where is that?
UGC scale of pay. Your Lordship kindly see Mamata Mahathi judgment. That is page 117. Delay and latches.
Page 117.
17. Delay and latches. In Mamata Mahathi case, the Lordship
Yes.
kindly see. They have referred delay and latches.
Yes.
In the very first appeal, the
What is the
respondent,
date of the judgment?
the date of the judgment is February 2011. 11. And I have filed writ petition in 2005.
Yes. Yes, where is that?
Delay and latches, pay 117, your Lordship kindly see.
Yes.
In the delay and in the middle para, delay and latches, in very first appeal, the respondents filed writ petition in 11/11/2005, claiming relief under notification letter 6/10/89 with effect from 1/1/86, without furnishing any explanation of such inordinate delay on latches on the plan. That has been pointed out and explained, and final judgment is, your Lordship kindly see. Page
Yes.
that is page 124, my lord. Para 49. 124, para 49. May I read, my lord?
Para 100?
Page 124, para 49.
Yes.
The full particulars of the respondent teachers are not before us, as in some cases there had been claim and counterclaim possessing the requisite mark, that is 50% in master course, as in civil appeal number 1253 of 2011, State of Orissa versus another Loknath Mishra and others. Thus, we pass the following direction. In case dispute regarding possessing of 54% of marks, the authority secretary of higher education, director of higher education may examine the factual position and decide the case of individual teachers in accordance with the law laid down in this case. If a person did not possess the requisite qualification on the date of appointment and was not entitled for granting a scheme unless he completes the deficiency, his case would be considered from the date of completing the deficiency of a grant of a UG scale of pay. However, in no case UG scale of pay can be granted prior to the date of acquiring the benefit of
Mr.
granted
Counsel, annexure 27
My lord,
at page 105,
my lord,
you are relying on for delay and latches.
My lord.
So this was in relation to the same.
Same, my lord. In Mamata Mahanti case, at the time of appointment, the teachers have a below percentage. Requisite percentage was 54. In my case, the deceased employee had 63 percentage having MPhil degree. And first post and third post of the very college given UG scale of pay on the basis of judgment of the Honorable Supreme Court, and the deceased employee holding second post of very college and being physically handicapped person denied UG scale of pay.
All right. Yes. So his writ application has been dismissed also on the ground of delay. Which issue is pending?
Is it correct that first and third have been granted,
Yes.
ignoring this middle?
Yes. Initial appointment to against cost.
No, what is his contention is first post and third post are given. Considering this Mamata Mahanti case.
That case, what has happened, those persons were appointed in this was three colleges. Before the cut-off date, they are entitled to UGC scale. In these cases, what has happened here, initially they were appointed against the first two colleges. Subsequently, that college, particularly degree college, they are claiming that we are appointed prior to cut-off date. And that college has been converted to a degree college. So we are entitled to that degree. In this, there are two types of judgments are there. In some cases, this Honorable Court has granted relief to them. In some cases, court has not granted relief. In those cases where relief is granted, state has approached the Honorable Court and that is paid. Unless that is final.
Pending, is there any order of stay?
In Mamata Mahanti case, that is Supreme Court judgment.
Supreme Court has a stay.
That is related to other cases. Other case
No,
relating to.
factually, he is calling out a distinction, saying that initial appointment was
First post, my
in the
lord,
junior college.
your lordship is right. First
Thereafter,
post is holding first post is appointed in the plus two. Therefore, in Ashwini Das case held that the college which has received government class for plus 3 degree by 1489, that is a degree college. That college is a degree college. Here, the college is opened degree for 8788. Cut off date relating to opening of degree. Therefore, the Honorable Single Judge, with due respect,
No,
misinterpreted.
there is no order of stay.
But in first case, they have been that copy not.
No, give us. As requested on behalf of the state, list this matter tomorrow. Tomorrow, Mr.
I can give it after.
Tomorrow.
Item number 3.
It's a writ appeal. It's directed against, it's a short chart I've given to your lordships. But the respond number 2 state, they made the resolution. I've just prepared a 1-page date for your lordship's appreciation.
Yeah.
Respond number 2 issued a resolution on 22/8/2023 fixing the guideline for engagement of junior teacher schematic.
What is the schematic?
Schematic means junior teacher, that's under a scheme they are being appointed. Maybe subsequently they may be regularized, but primary school, in elementary cadre, they have been, this is the guideline. On 10/9/2023, in terms of the resolution dated 22/8/2023, respond number 2 state issued an advertisement on 10/9/2023 inviting application for 20,000 post of junior teacher schematic through online mode. Then on 15/1/2024, the respond number 2 published the draft merit list of successful candidates that were totally 18,788. the draft merit list was prepared. Process was contemplated. After following that process, 18,788 candidates were successful. That list was prepared. That is a draft select list. Then 2024, some of the unsuccessful candidates was a market. Some four unsuccessful candidates, in fact, had approached this honorable court. WPC number 978 of 2024, challenging the draft merit list dated 15/1/2024. Then on 16/1/2024, the total 18,788 candidates, including the present appellants, whose name found place in the draft merit list, were called for the document verification on 21/2024 and 21/1/2024 by notification dated 16/1/2004. And out of 18,788 candidates, 16,218 candidates, including the present appellant, were successfully verified on the basis of the selection that draft merit list. Then on 12/3/2024, the Honorable Single Judge, by the impugned judgment dated 12/3/2024, quashed the draft merit list dated 15/1/2024, as well as the district-wise and categorized merit list. Entire merit list has been quashed now. That is the subject matter. The judgment of the Honorable Single Judge is the subject matter challenge.
Yes.
And I prepared the points because your Lordship wants always what are the real points. These are my very limited points so far I am concerned. I don't know the state and other councils are appearing for other petitioners. First of all, we are not made party. Not a single person, even in the representative capacity, those who are successful and those names found place in the merit list, those names were already verified for the purpose of appointment. They were not made party, not a single person. So first point I have formulated, whether the Honorable Single Judge was at all correct in entertaining and allowing the writ application bearing number so and so, when the writ application suffered from non-joinder of necessary party, and not a single successful candidate has been arrayed as a party, even in the representative capacity. The judgment I have given 2-3 Supreme Court judgment and one judgment by a coordinate bench of this Honorable Court recently, where my Lord Justice Raman was also a party. That Kavita Jana's case, that OPSC's matter, same thing. Then the next point I have formulated, whether one of the candidates, petitioner, who failed to achieve the minimum cutoff marks, thereby excluded from the state-wise merit list and subsequently modified district list, whether the writ application at all maintainable at their behest. Because their entire case was, this should have been district-wise instead of state-wise. That is their entire case. Now, during the course of hearing before the Honorable Single Judge, what I found from the records, the state government filed an affidavit specifically saying these 4 candidates, they have neither satisfied the last candidate who have been selected. These 4 candidates have secured less mark, both in category-wise, state-wise, as also district-wise. So on any circumstances, they could not have got the appointment. Then 3, whether the Honorable Single Judge was at all correct in interpreting clause 8.3 of the advertisement in holding that the preference in the district has to be given priority rather than the merit of a candidate. Now, Your Lordship, can look to the judgment. Before I take Your Lordship to the citation, I just, what was the question?
No, what was there in the advertisement? Whether it was to be district-wise or?
That is at page, Your Lordship, kindly come to page 20. Page 20. That is the advertisement. I'll take Your Lordship to that also. I will address Your Lordship on that point.
All right.
But before that, I'll take Your Lordship that whether the judgment can at all be sustainable without impeding a single person who was names found place in the successful list, in that merit list. That is my first point. And what was the question? This question was raised before the Honorable Single Judge by the state. Your Lordship, state will come to the impugned judgment at page 253. At page 253, internal page 26 of the judgment.
Paragraph
5.3. So far, the Lord Advocate General's contention is concerned. No, 2 I'll come later on in a different point. I'm addressing Your Lordship at 5.3. Lord Advocate General contended that since the recruitment in question is to fill up 20,000 posts of junior teacher schematic, and out of 20,000 posts, 9,982 candidates in category 1, 8,806 candidates in category 3 have been selected in different districts of different districts. State candidate of the state candidate so selected will be seriously prejudiced if the state is not permitted to proceed with the selection process. 5.4. With regard to the allegation made by the counsel for the appearing for the petition in the present writ application and to the submission of the learned counsel appearing in other batch of writ application, learned Advocate General contended that since none of the candidates whose names appeared in the impugned draft select list published under Annexure 6 series have been implemented as a party in the writ application, no adverse order can be passed without them being brought to the records. They are brought on records. In support of the aforesaid submission, Learned Advocate General relied upon a judgment of the Honorable Apex Court in such and such case. Quotation, I'm reading this quotation 3-4 line. One more submission, that was the quotation from the judgment reported in 2020-18 SCC page 673, para 34. One more submission raised by the Learned Counsel for the appellant in civil appeal filed by so-and-so case needs to be noticed. The submission of the appellant is that respond number 1 in this writ application number 1270 of 2008 did not implead any of the selected candidate out of the list of 832. No selected candidate having been impleaded by responder 1, the High Court erred in issuing direction to modify and review the select list. The direction of the Honorable High Court in paragraph 51 is clearly against the interest of the appellant, who as per the directions have go out of the select list having been published on such and such date, much before the date of the respondent filed the application for amendment of the writ petition for challenging the advertisement number so and so. He ought to have implemented the selected candidate whose names were already published by the MPSC. Respond number 1, without bringing selected candidates on record, could not have obtained any order adverse to the selected candidate. Then you also kindly come to page 257. 257, because I don't want you also to kill time. 257, that is, again, the contention of the Learned Advocate General has been also recorded by the Honorable Single Judge. Para 5.6, top, page 257, running page 257. Learned Advocate General also relied on the decision of this court, which I just was referring to, that Kavita Jana's case where my Lord Justice Raman is a party. Now, also relied on the decision of this court in the case of Kavita Jana versus so-and-so. Decided on 22/12/2023, this court in paragraph so-and-so of the said judgment has held as follows. Just first paragraph, last line. In the present case, the issue of non-joinder parties was raised at the earliest, but the same has not been answered. The aforesaid finding was arrived at by the court relying upon the judgment of the Apex Court, as discussed therein, and as such, the appellant have also relied upon those judgment in the present proceeding. Therefore, there is no iota of doubt that one single judge ought not to have proceeded without insisting upon impletion of selected candidate as opposite party in the writ application, that is WPC number so-and-so. Then we also kindly state to that judgment has been quoted in extensio. We also come to page 259, the last of 4 line of that judgment, that Kavita Jana's judgment, that page 259, internal page 32. When the right accrued in favor of the selected candidate have been grossly affected for non-inclusion of their names in the writ application, the writ application suffers from non-joinder party. But that judgment I have also brought, that was a case also where the draft merit list was prepared, a provisional merit list was prepared, that was subject matter of challenge. Then, sir, kindly come to page 274. That is the finding of the Honorable Single Judge. At paragraph 8.7, 274. With regard to the, let's get it. With regard to the stand taken by the Learned Advocate General that since the selected candidate whose name found place in the impugned draft result sheet published under Annexure 6 series have not been implemented as a party to the writ application is not maintainable. It is the view of this court that the present writ application along with the batch have been filed challenging the draft merit list published by OP number 2 under Annexure 6 series. Since the impugned draft result sheet is a draft list, though it has not been published in terms of the provision of para 8.3, and the final merit list is to be prepared after exhausting the provisions contained in 8.4 and 8.7 of the resolution related so and so. This court is of the view that since the list published under Annexure 6 series and the list published district-wise and categorized a draft select list, which is to be finally published only after completion of the process, so provided under 8.7 of the resolution, the candidate whose name appears therein are neither necessary party nor proper party to the proceeding. This court finds no substance with regard to the plea raised by the Learned Advocate General, and the writ application is not maintainable in absence of the selected candidate having been implemented as a party to the writ application, and decision rendered in case of Kavita Jana is not applicable. Now, Your Lordship, kindly look to the judgment. I have three judgment. I have brought to Your Lordships, and Your Lordship, kindly have a glance to that judgment. First judgment I'll show Your Lordships, which has been relied upon in that Committee Jana's case. That is Orissa Public Service Commission, our state's case, Priyamada Das case, in which a Supreme Court judgment has been referred to and relied upon. One paragraph, I'll take Your Lordship's time, one paragraph. That is paragraph.
Sir,
Para 7.
para 6 দেখুন তো।
And the 65.
6 এর কোশ্চেনটা ফ্রেম।
Yes, I'm just. Yes, sir. You expect kindly come to question. 6. Let's come to page 10. But sorry, that is internal page. 4. Internal page 4. The issue which was framed, Roman 3, whether the case suffered from defect of non-joinder party, since, sorry, madam,
Please, please.
paragraph 6,
Page number 4.
Roman 3,
Yes.
whether the case suffers from the defect of non-joinder parties, since all successful candidates of OCS preliminary examination 2011 are affected and have not been made parties, then your respect straight will come to para 24. But para 23 also, again, issue has been framed by the court. In that case, internal page 11, para 23. Upon hearing the parties,
Yes.
upon hearing the party, para 23, upon hearing the parties and on perusing the document, including the LCR, the following issue arising for consideration in this case. 1. Whether selected candidate of the preliminary examination were required to be made parties before the Learned Tribunal. Then para 24, 4th line I'll read. Coming to issue number 1, let us scan the various averment and prayer made by the OP number 1 in the original application. At paragraph 3 of the original application, opposite part number 1 makes it clear that it challenges the illegal action made in the preliminary examination 2011 by OPSC by adopting a wrong and illegal marking procedures. Then para 25 is the finding. Thus, one thing is clear, that on the ground or another, OP number 1 has averred that the result of the preliminary examination conducted by the petitioner has been vitiated, and accordingly, she prayed for setting aside the result of preliminary examination. As indicated earlier, about 5,823 candidates succeeded in the preliminary examination. As per Rule 12(1) of 91 rules, read with clause 2 of Schedule 2 of 91 rules, it is clear that the candidates qualifying the preliminary examination shall only be called to the commission by the commission to appear in the main examination. Thus, the candidate who qualified in the preliminary examination got right to appear in the main examination. In such background, it's needless to say that the selected 5,823 successful candidates have a right to appear in the main examination as per 1991 rules, which is rule made under Article 309 of the Constitution. Since the select list containing roll number 5,823 successful candidate has been set aside by the Learned Tribunal, it clearly offends their right to sit in the main examination. As per the law laid down by 4-judge bench of the Honorable Supreme Court in the decision in Udit Narayan Singh versus Swanso Supra, it is clear that persons who are going to be directly affected or against whom relief is sought for are necessary parties, and they should be named in the petition. It has also been made clear that parties in whose favor an order or notification has been issued, and when the same order or notification is challenged, the said parties are necessary parties. To the same effect is the judgment of Honorable Court in H.C. Kulwant Singh case, Supra. Even as per the decision in the case of Prashant Ramesh, Swanso, where result of the civil service main examination was under challenge, the Honorable Supreme Court has held that non-impletion of candidate selected in the civil service main examination was fatal. It may be noted here that even though a candidate selected in the main examination has no right to be appointed at that stage, but has a right to appear in the interview. In all India Supreme SC and Civil Tribe Employees Association case, Supra, the Honorable Supreme Court has made it clear that the candidate whose name are in there in the provisional selection, that's a market, in the provisional selection, even have interest oblique right in protecting and defending that select list. A reading of the decision rendered in Sadanand Holia's case, that Supra, makes it clear that the Honorable Supreme Court was not satisfied the course of action taken by the High Court in inviting the objection from the selected candidate who were never bothered to be made parties. In this context, the decision of Dr. Mahapatra in Swanso's case is factually distinguishable. There are Swanso's, let's skip over. Then the next judgment I'll show your worship, that's K. Siraj judgment. That your worship, see paragraph 52, only one paragraph. But, your worship, look to this judgment. K. Siraj reported in 2006 Supreme Court, page 2339. Paragraph 52. Paragraph 52, internal page 27. Page 57.
But you may get a line of decisions
Yes.
that when the policy itself is under challenge, which is to be defended by the state only, cannot be defended by the selected candidate.
My humble
Then
submission.
possibly the implement is not essential. There are line.
Here the policy has not been challenged. If you also look to that, they say that so far as the selection procedure adopted by the state authorities, that is not in terms of the policy. That is what they say.
That is not in terms of clause 8.3.
Right, sir.
That is the only.
That is there. But only after participation and only after the draft list was prepared, they have challenged it.
No, rightly. They could not have challenged before publication of
Right. That I don't say.
because they must have presumed
Sir, the only question is
that the states have act in accordance with what was there in the resolution.
Sure. Sir,
Right.
that matter still, we have to argue that matter. That's another part. But so far as the implication of party is concerned, if you have come to the court of law after the draft list was prepared, had the draft list has been prepared, their names could find place, they could not have come. But the draft list has been prepared. After that, they have come to the court. Now the question is whether at least in a representative capacity, all could not have been made parties, at least one or two could have been made a party.
All
That
right.
is what the law.
In any case, can the court now, appellate court should interfere in view of the clear provision under the clause 8.3 of the resolution.
That I will address also, but the 8.3 is concerned.
And the direction is only to the extent that you prepare district-wise merit list.
Sir, my point is there. Here also look to the written argument which was submitted by the state before the Honorable Single Judge I have given. Also look to that. That is a page. They have written one paragraph also. They have made an attempt to prepare a state merit list as well as the district merit list. In either of the two,
We appreciate your
Sir,
submission
sir.
that in either of the two lists,
they are not.
these appellants could not have succeeded.
Right. They have not qualified, even if they have not secured the mark which has been secured by a candidate like us, the last person who has been selected. That is page 77.
All right. Then in that case, the state could have simply followed the direction issued by the single judge by preparing district-wise list in terms of clause 8.3.
So far as we are concerned, the whole problem is now the ones that will be the judgment of the Honorable Single Judge is implemented, so far the casting of the list of the recasted, then we'll be nowhere and we'll be affected. We are adversely affected.
You may be affected, but can you make a submission? Can you make a submission against clause 8.3?
Sir, I am not. I have not made any attempt to make a submission against clause 8.3. I'll show that. But my first point before your lordship is, my submission is that implication of parties, because that is very fatal. Even the Honorable Supreme Court has said,
Suppose we set aside the order.
Right, sir. What argument I can advance? That your lordship may put the question. Yes, sir.
What directions? you oppose the stipulations in the resolution?
No,
Like
I cannot. I cannot. I
88.3.
must go by the
My lord,
regulations.
would your lordship then permit me? Because I have filed an appeal also. Kindly see, my lord, just see, kindly see page 5.2 of the judgment. I'll refer to the page my learned friend is referring to. Page 5.2 of the judgment. Internal page 26, running page 253.
Yes.
My lord, I had argued that the petitioner's names do not find in the draft merit list. Now, let me tell you, lordship, the context of this. There were 20,000 posts. Now, there were 85,475 candidates, out of which, my lord, 18,788. May I tell you, lordships, again? I'm sorry.
Please.
There were 85,475 candidates
For 20,000.
for 20,000 posts. Now, 18,788 called for document verification. And then, my lord, total number of people who appeared were 16,217. Now, post document verification after the draft list, today we are at 15,815. Today, if you have a 15,815. The petitioner's name did not find place in that 1627. So we had submitted before the learned single judge that in any case they are not qualified because they are not there in the draft list. So therefore they have no locus. Whether it will be
Yes,
8.3, whichever way, they have no locus. The single judge, my lord, with great respect, did not address that. That is one point. Now on 8.3, let me straight away come to 8.3 minutes. And that your lordships will find in this writ petition. Let us see, my lord, that is, if your lordships kindly see, my lord, the resolution is at page.
We are there at
Lordships have it, my lord.
8.3.
Your lordship may see, my lord, before your lordship sees 8.3, kindly see, my lord, there is a clause 3 which says advertisement. My lords have it.
Yes.
So OSEPA on behalf of the school and mass education will publish an advertisement in a widely circulated ODI English daily newspapers inviting online applications for intending application for engagement as so and so. Now, my lord, kindly see 8.1. My lord, what has been missed out is really 8.2.
Yes.
My lords have 8.1, my lord.
Yes.
Selection procedure. Publication of master list. After expiry of the last date of submission of online application forms, list of candidates for each category with respect to their first preference districts as submitted by them at the time of submission of application form will be published in OSEPA website. Information on subsequent preference districts of each candidate will also be available in OSEPA website. Now, my lord, if your lordships have that application, which an applicant makes, he gives a preference of 30 districts. So it is not as if one applicant is saying, I am only giving Baleswar. He gives 30 options. 30 options. Now let us see, my lord, what is 8.2.
In the order of preference.
He gives. I'm grateful. But he knows that he will be fitted into one of those 30s. That's the point. When he is giving 30, he knows he will be fitted into one of those 30.
So is this your submission?
Yes,
that
madam.
the list which was prepared, that was under 8.1.
The list was-
stage had not reached. No, this is not your submission.
My lord, now comes 8.2. No, that is not my submission. 8.2 says an online computer-based test will be conducted by OSEPA, an authorized agency, as per the syllabus contained in the advertisement, to be published before the recruitment. My humble submission to your lordship is following. This online computer test is a test to determine your merit. And my lords, for determining the merit of the applicants, the single judge says, my lord, the Honorable Single Judge A does not refer to 8.2. B, he says that merit has to take a back seat, preference of district has to take a front seat. That's the short point. May I say it again? 8.2 was inserted to hold a computer-based test amongst the applicants to determine their merit. 8.3, if your lordships read 8.3 along with 8.2, the inescapable conclusion is that merit has a very important role to play in selection of teachers. But what are we doing ultimately? We are selecting teachers to teach students. And if your lordship sees, my lord, this,
No, how do you say that? This is
Yes.
the finding of London Single Judge.
Lord, now kindly see the three lordships have read three.
So whatever merit list was prepared
I'm grateful.
by you
Yes.
was on the basis of this 8.2.
8.2. But there are two submissions. 8.2 will select a candidate. 8.3 will say, I will allot you this place. And you have given me a list of 30 in your application. Now kindly see, my lord, how does the learned single judge deal with this?
No, but did you prepare a
Yes.
draft merit list?
Let me show it to your lordship straight away.
The document is to the district incident.
No, the first one.
As your draft app.
Kindly see, my lords. Then please let me see the first one. No, my lord, before your lordships come to the list, kindly see page 38 of that brief my lord friend was replying.
Yes.
My lord, this list has not been challenged and they have appeared pursuant to this list in the examination. With reference to certain media reports regarding the recruitment of junior teachers, schematic 1 and 2, it is to inform you that so-and-so has been entered into an MOU with Odisha school. You'll may skip all that. Let me read it. The CBT was conducted in accordance with the requirement of so-and-so. The resolution provides guidelines for engagement of junior teacher schematic, including application, submission model, eligibility age, reservation list, certain criteria of selection process, methodology of finalizing the merit list. Response query management was done and all objections were addressed. After conducting the computer-based test, EDCIL prepared the results as per the guideline provided in the resolution dated so-and-so to the authorized designated officer of OSEPA. Now kindly see, my lords, kindly turn to the next page. That is the list. That is the list that was prepared at the first instance. Now, if my lordships will kindly see, my lords, kindly look at serial number 1835. Extreme left. My lords have it.
1835,
Serial number, page 39.
page 39.
Just after that page.
First number.
Yes.
This is an abstract. Now, kindly see, my lords, the person's name is, the roll number is there, application number is there. If your lordship sees serial number, then application number.
Yes.
Then kindly see, my lord, roll number. Then kindly see junior schematic category 1, science, Keonjhar. Now, my lord, what your lordships are seeing is the merit list of the various candidates. And once the merit list is prepared, then whoever is fitting into which district it has given, the submission to your lordship is merit has been given preference in preparing this list. Let us say, my lord, I prepare a merit list of first 100. So I now pick up who are the first 100 candidates. And then I try to fit in their district preferences accordingly. What the learned single judge says, my lord, with great respect, that you first give them the district they want. And I will show that to your lordships. Merit cannot prevail over the district preference. Now, that is the short point which your lordships have to consider, my lords. Kindly see, my lord, what is the finding of the learned single judge. Okay. Now, my lord, if your lordships kindly straight away comes to my lords. The finding, right, Page 8.8. My lord, Lordship may see first, my lord, paragraph, page, the internal page. My lord, 1 second, my lord. Your Lordship, don't mind. Yeah. Then would your Lordship straight away come to minutes, para 8.8, internal page 48, page 275. Page 275.
Yes.
Since this court finds that the draft merit list published under Annexure 6 and or consequential district and category wise list by segregating the names of each 30 districts so produced in a seal cover before court has not been prepared in terms of the provisions contained in para 8.3, the resolution placing reliance on the decisions of so and so, I cited this court, is inclined to interfere with the draft result sheet as well as the district and category wise list for each of the districts, segregating the names so produced before this court in a sealed cover. My lord, the next paragraph. The stand taken by so and so that the merit list is the sole criterion. Now, this is the argument that merit is the sole criterion for selection of teachers, and that has been followed is not acceptable as it runs contrary to the provisions contained in para 3 of the resolution. Taking into account the submissions of so and so, the list of successful candidates have been prepared, taking into account their performance and merit. It can be inferred that the stipulation contained in 8.3 of the resolution has not been followed. Since the provisions of 8.3 is very specific, that selection of candidates only basing on their merit, irrespective of their district, of their preference, given for a particular district is not sustainable in the eye of law. This court accordingly is inclined to quash the draft list published under Annexure 6 and so also the district and category list published so and so, before just produced before this court. While quashing the list, this court directs the OP number 3, now this is important, to prepare district-wise, category-wise draft merit list in terms of the provisions contained in 8.3 of the resolution dated so and so. After such publication, the district-wise category shall proceed with the selection. So therefore, millards, what the learned single judge says is that you forget your 8.2 CBT exam, you forget your merit list, give them as per district preference, namely, irrespective of what mark he has secured in the CBDT list, if he has given Bhadrak as a preference, tabulate all Bhadrak. This tabulation on the basis of their merit is not in conformity with 8.3, and without saying that why, then what was the basis, what was the reason for 8.2? There was no necessity to have a CBDT test, because everybody will be given as per. So in other words, millards, I will now select teachers who are less meritorious and give them the district preference and appoint them, and leave out teachers who are more meritorious. Just 4 lines of a judgment of the Supreme Court, millards. Where is my copy? Where is my marked copy? Just give it. This is the one. My lords, may kindly see paragraph 2 minutes.
Yes.
This is Anmol Thakur, Kumar Tiwari. This was also cited.
Yes.
But this was also cited.
Yes.
A high-level committee was constituted by the state government to examine the irregularities in the selection process. The report was submitted by the DIG police personnel, state of Jharkhand, in which it was found that select list was prepared wrongly by ignoring the merit of candidates and giving them undue preferences given by them. Your Lordship may straight away come to para 12 minutes. Just 4 lines. This is at page 428. My lords have it, minutes.
Yes.
Para 12. The second issue relates the claim of the interveners in the writ petitions for appointment, there is no doubt that selections to public employment should be on the basis of merit. Appointment of persons with lesser merit, ignoring those who have secured more marks, would be in violation of Article 14 and 16 of the Constitution. I rest my case there. The submission to your Lordship is that 8.2 read with 8.3, read with Article 14, read with Article 16 is the real answer. The learned single judge says, my lords, that you ignore 8.2, forget merit, only go by 8.3, even though 8.3, my lords, go only by 8.3. I am quashing your select list, which is based on merits. Now you give them as per the district preferences. Net, people who did not even qualify, like the petitioners, they were not in that list, or people who are down below, will now get in. And people who are more meritorious, they will be left out. In short, my lord, that is our case. And today, if I have to continue with this process, I will be appointing about 12,000 candidates roughly. But the point is, my lord, merit is going to be compromised.
No, but on conjoint reading of 8.2, 8.3,
Yes.
8.4,
Correct, my lords.
it is apparent that you have to prepare a merit list on the basis of
There is no difficulty there.
8.2.
My lord, that is no difficulty.
That cannot be
My
compromised.
lord, let me answer that question, subject to your lordship's kind consideration. It is this. I have shown your lordships a master list. Now that master list, when this question was posed to me, I told the learned single judge, and I did file without a district-wise list. But what the learned single judge has said is that this is also wrong because you have gone by the, suppose not Bhadrak. Let us take, for example, Bhadrak. I go by the candidates on the basis
No,
of
that
merit.
would have been a situation
Yes, ma'am.
had the selection process been district-wise.
Yes, I'm grateful. I'm grateful.
The matter would have been different.
I'm grateful. Your lordship
this is
answered my
as-
question.
In fact, as per the resolution,
Yes, ma'am.
you had gone for, say, competitive examination.
I'm grateful.
Competitive test.
I'm grateful.
To have a merit list on the basis of the vacancies which you have.
I'm grateful.
And then you were required to prepare a merit list district-wise, of
Correct.
course, keeping in mind their preferences.
Preferences.
So that was all.
So, my lord, what did I do? Your lordship saw that page just now, which my learned friend showed, my lord, that page. Kindly see, my lord, kindly look at page 39 again, my lord.
Required to give their preferences.
My lord. And 30 is what they gave. Who pages of 30? Is it there? The briefs are so voluminous. Lordship may see, my lord, this applicant gives. I'm sorry, my lord, Justice Raman doesn't have.
So,
They give 30 preferences.
right,
Yes.
right. So they had given preferences
Of
at the
30
time of filing of the applications.
I'm grateful.
And based on their preferences, you prepared a merit list. Not based on their preferences, you prepared a merit list
I'm grateful.
and you allotted a particular district based on the preferences.
I'm grateful.
Or the candidates already selected might have a grievance that I have not been allotted a proper district.
No one has come.
Therefore, a person may claim
Correct.
I ought to have been given
Yes.
a puri instead of badara.
I'm grateful.
All right.
I'm grateful.
So this can be this thing. But if you prepare a merit, even if you prepare a merit list,
Yes.
district-wise,
Yes.
a candidate may say that my preference was this, my first preference was this, I had better merit position. Still, someone of
I'm grateful.
less merit has been given.
Correct. You will be absolutely.
These circumstances can emerge.
Can emerge, no difficulty. Because he knows when he's applying that I will be considered one of those 30 districts. That is why he's giving 30. Now kindly come to page 39. What has fallen from your lordship, my lord, is exactly what page 39 is. I prepare a merit list. I give them allocation. One of the merit list persons can come and say that, look, I could have got Puri, you have given me Dhenkanad.
And that is therefore it is draft.
Therefore, it is draft. And
Maybe.
no one who has qualified, who is a part of the merit list, is before your lordships complaining this. But I bow down to what your lordship is saying. But if your lordships hold, as the learned single judge has said, that district-wide preference will prevail over merit, I have no case. I have no case. But if 8.2 has to be given some meaning, and pursuant to 8.2, one test has been held, and based on the mark, a merit list has been prepared, and then districts are filled up, and somebody who has qualified, who is in the merit list is complaining, would be a question where lordship may consider. Here,
No, but why this district-wise list was placed in seal cover?
because my learned single judge said that this is not a district-wise list. So what we did, we broke this list into districts. For example, my lord, if your lordship sees page 39, just as an illustration, suppose there are 5 Mayurbhanjas. We put all Mayurbhanj in one list. We put. But he said, no, this is not good enough. Because you have prepared this list. You have prepared this list on the basis of merit. So merit could not have been, because 8.3 says it is district preference. So everybody, you first take out the district preferences, irrespective of the merit. Suppose Baleswar, my lord, 20 people have applied, fill all 15 in Baleswar first. In other words, my lords, give a go by to 8.2. As the lordship said, my lord, Supreme Court now says 14 and 16 says that merit is a very relevant criteria.
Who is appearing for the other side?
In fact, to add to this, my lord, if the lordship says.
No, someone is appearing for the other side.
Yes, yes.
I have the instruction, I did not get, and I have the writ petition, I have website. I have not filed power, my lord. Because the
File it.
clients, they 4%. They could
My
not
lord, your
file
lordship,
Talk
may,
tomorrow.
my lord, may I submit something?
I will submit, my lord, but.
My lord, may I make a small submission?
Just a minute. What we intend to do is, you are 4 persons.
No, there are other batch of cases decided. I was only the.
Let us say, my lord, there are 200 persons.
There are batch of cases.
My lord, I have 15,000 candidates out of 20,000. I told the honorable single judge, my lord. My lord said, keep 500 posts, because in any case, I am not filling up anything more than 15,000.
So if he can address tomorrow.
Fair enough, no difficulty.
I have also filed a caveat, my lord.
May I just at one point? The entire 8.1 to 8.3, basically what it meant was this, that the state is never going to compromise and have a teacher which does not meet the qualifications under 8.2. So they went out of zone of consideration because they did not pass that exam. Then 8.3 comes in between those people who have cleared 8.2. Then I mean, after they were out of the zone of consideration because they were not fit to be teachers. And then amongst who are fit to be teachers, they would fight it out among preference and the marks you secure. That is how the whole thing should have been viewed. But what the single judge thought, no, you put it only district-wide, because if that argument is taken to its extreme, then a person who secured 0 can also get the last post, say in a district like Khurda, where there may be more posts. So therefore, there is an absurdity in that thing. State never intended to compromise with the merit. And I believe that's the substance was.
And I was also.
So there are how many appeals?
But there are 3 to 4 appeals. Four appeals.
Altogether 4 appeals.
One is mine, the rest are,
Just trying to supplement
one is
saying-
mine, the rest are successful candidates.
I will request my friend to supply the copies.
Yes,
so
yes,
that
just now.
there is one of
No,
the-
what I suggest to-
Intervention of this. So I will be supplied with the copy.
No, you are supporting or against? Yes, supporting us or against us?
No, no.
Successful candidate, no, no. Come here.
So once they
Yes.
cross over 8.2, they lose their locus. And because we have crossed over 8.2, we become the necessary part.
Clarify.
And that's where Mr. Rautrai's judgments would come into.
Very vital point came to my lord's mind that they have a right of objection, clause 8.5. Once the list is published, in terms of clause 8.5, objection will be invited, as your lordship rightly.
We will not observe in our order.
Absolutely. Correct, but then your lordship
But the-
sees 8.5. That is what is there.
The best course would
Is
be
there.
subject to your lordship's acceptance, as rightly suggested by Lord Advocate General. There are about 15,000 vacancies are there, 20,000.
20,000.
Best course would be
Yes, madam.
that this appeal is decided tomorrow.
Yes.
Yes. Very fair.
All right.
Very, very.
Absolutely.
If he is also there,
Yes, yes.
there is no requirement. All right, sir. So we will hear all of you.
Fair enough.
There is no requirement of issuance of notice.
My lord.
We can decide the matter tomorrow.
Yes.
We want that.
All right, that will be the best
Yes,
course.
yes.
Why interim order? Why waiting?
Kindly give.
Yes.
Yes.
You supply your email ID. So
See, you will-
so that you can get, yes, you can get it. So this is a fit case when we can turn this court into
E-mode.
Immediately.
I am not equipped by that.
In view of the
You are already having,
in view of the volume of the briefs.
Why your lordship will burden
she is
tomorrow?
already,
Because tomorrow is a Friday.
Yes.
Why not on Monday? Your lordship keep it to Monday and to dispose it.
All right, Monday.
Fair.
And you have already heard the submission.
Yes. I was watching.
He was very much from the beginning.
Yes, sir.
Ah.
We will serve it. Quite fair.
This matter heard for the appellants. This matter on
Monday at 2 o'clock.
Monday. No, why at 10:30?
Okay.
10:30.
Okay.
10:30. If
Yes,
it's required,
yes.
we can dictate.
Yes, sir. Yes,
Dreadful.
yes, please.
This is on Monday for further hearing.
Grateful.
Retaining its position. Can decide it on.
4.
May I appeal, Your Lordship? My lord, the petitioners praise for that the names of the petitioner institute can be displayed in the state scholarship portal for which the petitioners will apply for a scholarship, my lord. And the similar matter, this honorable court has passed order, my lord, to take instruction from the government council.
This is PIL.
No PIL, my lord. The petitioners are continuing their studies in the ITI, my lord, private ITI colleges, my lord, fitter and electrician. Last time you also directed, my lord, that is a similar matter. Take instruction, my lord.
They have to be published on the website,
My
web
lord,
portal, including the private.
my lord, private.
ITIs.
But some of the private ITIs have been, their name has been displayed in the state scholarship portal, but the concerned petitioners institute has not been displayed in the state scholarship portal. Therefore, the petitioners, SC/ST candidates, my lord, they have not applied for the state scholarship portal because the institution of the petitioners institute has not been displayed, my lord. And in the meantime, my lord, the state government, that is the opposite parties, have fixed the last date for apply the state scholarship portal is today, my lord, 25th, my lord. Today I have filed a I petition, my lord. The petition may be permitted to allow the state scholarship portal till disposal of the writ petition, my lord.
So what is the compulsion for the state to notify? Why this institute should be notified?
My lord, the petitioners are the scheduled caste, scheduled type candidates. They are continuing the study after getting the scholarship from the state government, my lord. The government has sanctioned scholarships to the SC/ST candidates to prosecute their studies, my lord. The students have been selected through state government, my lord. State government, that is the portal, my lord, SAM, that is.
You were selected.
My lord, I have been selected by the government selection committee, my lord. And they have, according to their selection, they have selected the candidate to admit in different colleges, government ITIs and private.
You were selected for admission in this institution.
Yes, my lord.
Brahmani Private ITI.
My lord, on the basis of, my lord, merit, my lord. First, students will go to government college, then private college.
So this was the this allotment was done by the state government.
My state government, my lord. Now the only source of income the students only to pursue the studies through the scholarship getting from the state government.
Yes.
I have seen that there is no government that you are selected by the state government and is prosecuting your study in a private ITI.
The scheme is also not there.
That scheme is in respect of government ITI.
No, there is.
Para 14, my lord.
Now, have you included that scheme?
My lord.
Have you made that scheme part of record?
My lord, no, that is the petition, the previous year, the institution of the
The scheme of scholarship.
Scheme for granting scholarship. My lord is asking that scheme.
That is my lord.
What is it meant for?
My lord, in the para, in the
and they must be giving it to the government institutions where the these
here they are admitted to private institutions, but he is claiming that because that is a
no, Mr. The government may have a policy.
Yes,
that if scheduled caste, scheduled tribe candidates study in
irrespective of
these private institutions.
Irrespective of the institution, whatever either government or private, then they are entitled to. So
no, not all the institutions. Institutions recognized by the state government for the purpose of grant of scholarship. So if there can be such policy, if there is such policy, and he was selected for a scholarship, and he was allotted a particular college, then he would be entitled to. He should be given
that instruction I can take. And
so where is the policy? Where is the policy, Mr. Khan?
My lord, In the paragraph, so that is my lord, page 20, my lord, the previous year, that is annex of 4, my lord. Previous year, the college has already getting
Mr.
scholarship.
That will not do.
May I
We will
submit my
have to
lord?
see the policy. You just talk
Yeah,
to the
yeah.
department today.
Your lordship has fixed it to 2nd July. Similar matter, your lordship,
2nd July.
your lordship has fixed it to 2nd July. I'll talk with the department.
Today itself.
Yes, ma'am.
We will take up the matter tomorrow.
Not tomorrow,
Because-
day after, on Monday.
Let it come tomorrow.
My lord.
Make an attempt.
My lord, I'll take
If you are not in a position to get instructions, it's a different
Yes, my
matter.
lord, I'll try
But
to.
it's a question of a scheduled caste candidate studying
I understand.
and otherwise without a scholarship, he cannot pursue his studies.
I understand.
There are two aspects.
Well,
Sometimes these applications are filed, these are proxy litigations. All right, it may happen that the institute asking the candidate to make an application so that more and more students, SC students are admitted in the college.
Private.
This is also a situation.
Right.
The other situation is that even in that circumstance, if a candidate has taken admission after having been found entitled to a scholarship in a private institute, it should be given that benefit.
Definitely, I
So these
take-
are two.
And what is the scheme I'll take
As
with
it,
that
as
scheme?
it appears, his institution is within the portal of, within the compass of this SAMS,
No, all the institutions which are.
Student Academic Management System.
Yes, ma'am.
SAMS.
Now all the private institutions are the SAM.
They are within their fold.
Yes, ma'am. Those were
So
recognized by the
must
AICT and
be
the government, approved by the government.
Otherwise, that serial number would not
Yes,
have come.
that only I have to see that what is the scheme and whether
What is
that.
the scheme, and please inquire
Well-
whether because of any lapse or sometimes you miss out,
Yes, ma'am. That
he is going to this thing not avail the facility.
well.
List this matter tomorrow under the same AD or then AGA to seek instructions. Yes, who is for the state?
My lord, I'm here.
What is your opinion?
My lord, they say the challenging the construction of a Kalyan Mandap on Gochar land without following the procedure. That is his allegation. And he's a senior local person of that area. That is his allegation.
No, but what is your view? Whether
My lord, I didn't, because if it's a developmental work, my lord, the government, the authorities would have taken the proper steps to do it, my lord. And if surplus Gochar lands are available, the government can go ahead with the developmental plan.
there is no representation on behalf of the petitioner? Learned AGA so is present. So it is the petitioner's grievance that that a Gochar land is going to be utilized for construction of
Kalyan Mandap.
Kalyan Mandap without following due procedure. So the nature of next. Considering the facts and circumstances, this application is disposed of with the only observation that it is expected that if any construction is to be made on a gochar land, the concerned authority shall follow the prescribed procedure. And follow, shall act in accordance with law. Follow prescribed procedure, shall act in accordance with. The application stands disposed of.
Item number 6.
All the batch of cases, Lords. Now I've got the instruction at about 5:30 PM in the last evening, Lords. The final department has placed with the executioner 3 crores 26 lakhs. And from today, Lords, morning itself, the executioner says that disbursement has already started in course of the day, it shall be completed, Lords.
My lord, your lordship's last order. My lord, on instruction 5 minutes back, that not a single payment has been made. My lord, your lordship's last order was
4:30.
my lord. My lord, your
Come at
lordship.
4:30.
My lord.
No, may I please say one thing? My friend is saying so. The executioner present in court, Lords, may call him, Lords.
No, but you have started payment from today.
Yes, today I'm saying that yesterday evening at 5:30, the amount was placed with the executioner by
All
the
right,
finance
but the
department.
amount has not in fact been paid.
No, it has, Lords, individual account, they've started making payment, Lords.
Then what is left?
And we have got the amount, why should they not pay, Lords? I don't understand. We'll pay definitely, Lords.
Okay, my your lordship may keep it in Monday. So that ensure payment, my lord, because in the last occasion, they have said the funds are available with us and we need some time to payment. Now, my learned senior is saying that the funds are available yesterday evening. In the last order, your lordship's order.
From today, they are disbursing the amount also.
My lord, your lordship may keep it Monday. So
No, we'll
that,
take up at 4:30.
my lord.
How?
Because I don't need so many things again being listed, Lords.
My lord,
repeating.
on 4:30.
Lords, may take it at 4:30 before rising.
My lord, my lord.
No problem.
4:30.
Item number 7.
May I please your lordship, I am in VC. I may be permitted to make my presentation.
Yes.
Lordship. Lordship, this is a content petition relating to acquisition of the land of the petitioner for which no compensation is paid. The land acquisition notification is of 2013. The writ petition filed in 2020 and 25th August 2021. Honorable Division Bench has passed an order in a batch of writ petition saying that all these people are entitled to compensation. Since this particular petitioner was not in that batch of petition, so his matter could not be taken along with that one. So when it was being taken, honorable, since it was placed before the honorable court, that since it is a cover matter, that's how honorable Division Bench has passed an order on 6/12/2022. That since it is a covered matter, so it is to be
2 orders. He had not given those orders, that's why Lordship directed him to supply the documents. So Lordship kindly look at
already
the
that I have
document.
given. I have given.
You have not given to copy neither to me, not to my
But-
friend who is applying for the NHI.
Yes, copy has not NHI also today I have said, I have sent today through, so for the NHI is concerned.
No, I have not received copy.
Sir, kindly check your WhatsApp.
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 Else I can give you a
WhatsApp.
printed copy also.
I'll take a printout and see.
It is stated by Learned Counsel for the petitioner that in compliance of this court's order dated 28/3/2024, for copies of the judgment an order dated
6/12/2022.
no, some 21 something.
10/6/2021 and the final order is of 25/8.
2021 have been supplied to the Learned Counsel for the NHAI on his WhatsApp. Learned AGA has submitted that he has not received copies of the said decisions. So is this case on Monday? So,
May I submit your chip? In fact, so for the government copy, we have already served a copy with the government in the counter. That is also with us.
25/8/21.
20.
10/6/21 as well as 25/8/21.
Operative person of order dated 25/8/2021, paragraph 2, your lordship may see. The only direction that now required is to be issued to NHI to complete the above exercise, approval, sanction, placement of funds. The direction was given to NHI. In the content petition, the petition has only implemented the LAO as party. No authority, NHI authority has been implemented as a party.
Then how contempt is made out?
And that is filed. That was filed more than expiry of 1 year. The contempt has been filed.
How contempt is made out?
Contempt is not made out.
Lordship, may kindly see. So far the contempt is concerned because competent authority under National Highway Authority Act is the ADM.
National
Additional
Authority,
District
Highway Authority
Magistrate.
was not a party. How can we initiate
They are
contempt proceeding
ADM.
against a person who was not a
Lordship, may
party?
kindly see. ADM is the competent authority under National Highway Authority Act. So ADM NHAI, competent authority NHAI. That's
No.
Just a minute. Just a minute. Where is the writ petition?
No.
Whether in the writ petition NHI was a party?
Yes, Lordship. As a in the writ petition, a party and ADM, additional division, additional district magistrate, competent authority.
Just a minute. Whether in the writ petition NHI was a party or not?
Lordship, 1 second. I have the copy. Yes, Lordship. Respondent number 3, competent authority, additional district magistrate Raurkela. That is 1. And respondent number 4 is executive engineer, National Highway Authority Division. So for the land acquisition part is concerned, it is respondent 3, competent authority.
Why are you saying?
It's a land acquisition part.
NHI was not a party in the writ application, my lord. But
You are reading writ application or contempt application?
Writ application is reading.
Lordship,
Mr.
Read,
Counsel,
Lordship.
in the writ petition, executive engineer was a party.
Yes, Lordship.
He is saying he was also
In writ application,
National Highway Authority.
in contempt, he has not implemented. Contempt only he has implemented LAO.
all right.
He is the disbursing authority.
One thing, Lord, NHI will place the funds with the present contender whom is a
We
made a
don't
party.
know. We will proceed against only such persons who have been implemented.
That's the
Yes,
thing, Lord.
because
Where direction was to the NHI.
direction was given to the NHI.
Now he has implemented me instead of saying that I am not complying.
Lordship, competent authority NHAI is the land acquisition officer. Unless they proceed with the award, then the National Highway Authority who are supposed to disburse the amount can't do so.
We will
So for
go
the
by the
award-
order. We will go by the order.
Lordship.
Mr.
Order
Counsel.
says the only direction now required is to be issued to NHI is to require the complete the above exercise of approval, sanction, placement of funds within a period of 4 weeks. So NHI authority should be implemented as a party in the contempt proceeding.
Should be initiated and should be implemented. So you want
Yes,
yourself to be implemented?
No, he has not implemented, my lord. That I'm pointing out. And the contempt was filed after expiry of 1 year also. Section 20 is bar. 6/12/2022 is the order. The contempt file is in 2024. More than expiry of 1 year.
Under which provision? Bar is under which provision?
Section 20 of the Contempt of Court Act.
And we have power under Article 215.
215, yes.
Then, is there any bar for that?
No, that I'm pointing out. That your lordship has power under 215.
Let us see, we will see on Monday or Tuesday.
Yes,
You please give the order. Do you have a
No,
copy
no
of
petition has been served. Let me serve a copy of.
In the order, in the order, we have mentioned that in the order dated 28/3/2024.
Yes. 25/8.
28/3.
23/24.
Second one. Yes.
We have mentioned about those two orders. Pawan Kumar Agarwal.
Yes.
You can get it.
Yes.
Can't you get it?
Pawan Kumar Agrawal, yes.
You can get
then-
both the orders. Why the petitioner should supply?
No, Pawan Kumar Agrawal also there.
In terms of Pawan Kumar,
Yes.
we have disposed of.
Yes.
So the contempt is against that. So you have to comply the terms of Pawan Kumar.
Yes.
So you take instruction whether you
Yes,
are, you are to comply or not.
Have you
to comply
complied
or
with?
Yes.
You are not complied.
That I'll.
Matter ends there.
Yes. That I'll.
6 weeks time is allowed for the contemners to file affidavit as to whether this court's order dated so and so violation of it, which has been alleged in the present contempt application, has been complied with or not. Yes.
Item number 8.
Posted. Let's see, posted to after. Oh, obliged.
Item number 8.
Item number 8, I'm filing the compliance affidavit. The lordships were pleased to direct the officer to remain present. In fact, he is present before lordships, and he has already taken a decision since 13th of April 2024.
13th of April.
March, 13 March 2024 at page 7 annexure B. He has already taken a decision saying that he is not competent to, because he is the additional district magistrate, he is not competent to transfer the lease in favor of the redress of the present petition order. So it's only either collector or the state bureaus.
Yes, the order has been passed.
A copy of that.
I am giving to my friend. Just now we have filed it in court. That's why I am giving my friend.
But the initial resumption proceeding was initiated by the ADM.
So that this order may be illegal.
This honorable court interfered and directed the ADM to reconsider our application for transfer.
So whether this court conferred jurisdiction on him.
No, your lordship.
So according to him, he did not have the jurisdiction, therefore he has disposed of the matter. So
The lordship, the present contemner being a officer of the equivalent land of of the collector.
the order may be illegal. This is what we are saying.
Yes,
You
sir.
may have you shall have the liberty to challenge the order. In the present contempt application, disobedience of this court's order dated 28/2/2023, passed in WPC number 20117 of 2022, has been alleged. Stop. London AGA appearing on behalf, who is he? Who is the officer?
Vibhuti Bhushan.
Vibhuti
I
Bhushan
am
Naik,
giving the
Vibhuti Bhushan Nayak.
additional district
additional district magistrate.
Additional District Magistrate Mayurbhanj is personally present in court. Stop. Learned AGA appearing on his behalf have produced before us an order passed by him on 13/3/2024 in compliance of the said order of this court dated 28/2/2023. Stop. And counsel appearing on behalf of the petitioner has, however, argued that the additional district magistrate ought to have decided the petitioner's grievance on merits, as he had the jurisdiction to decide the dispute. Stop. by the said order dated 13/3/2000, in the order dated 13/3/2024, the contemner, additional district magistrate, has noted that since the
Yes. Last but one line, but it lacks jurisdiction of the undersigned to consider the application of the petition for transfer of the.
where?
Yes, page 8. Last but
Noted
two lines.
that he lacked the jurisdiction to consider the petitioner's application for transfer of the leasehold land, which was vested in the collector.
Yes, only the collector is the competent authority.
Full stop. Full stop. In a contempt jurisdiction, we are not required to enter into the legality of the order which has been passed by the contemner in compliance of this court's order. Full stop. It will, however, be open to the petitioner to question the correctness of the said order dated 13/3/2024 before appropriate forum in accordance with law. So stop. Though we are not though there has been delay in compliance of this court's order, considering the subsequent conduct of the contemner and you have not made any apology. You have not tendered apology.
Yes,
Yes. And
paragraph 7.
all right.
Para 7 minutes.
And in view of unqualified apology tendered by him, this contempt proceeding stands stopped.
Much obliged.
You should have replied to your letter.
He has some problem. He is hard of hearing, and that is why there was some communication gap.
Item number 9.
Item number 9, lordships, now the other benefits has been granted to the petitioner. He is to get 1,34,000 and odd. Now it has been placed by the college where he was working on 23rd of this month. So 13/4. 13/4. So now lordship only grants 7 days time. In the meantime, the amount shall be paid to him. It will be complete.
On 28/3/2023, you are directed to fully comply with the order.
No. It has been, you can also see the 13/4, the requisition order made by the
In
college.
view of the submission made by an AGA representing the contemner that this court's order dated 3/4/2023 passed in WPC number 8976 of 2017 has been substantially complied with, and the remaining part of the order shall be complied with soon, this matter is adjourned to 1 week, by way of indulgence. So, what is this matter? Yes.
Item number 10.
May I please, your lordship? My lord, this contempt petition was filed for non-compliance of order dated 6/3/23, Annexure 1, page 10, and operating person, page 11.
Yes.
Now, some time may be given, I can obtain disposal of the representation. I will obtain instruction now.
We requested on behalf of the contemners, list this matter on 4 weeks. So as to ensure, so to report full compliance of this court's order dated 6/3/2023.
My lord, next sub item also similar matter.
Why do you receive such orders? You could have got your dispute adjudicated upon. You wanted your disposal of your representation. So one case is generating 4 cases.
Item 11. May I please, your lordship? National Green Tribunal order, my lord, was challenged before the Honorable Single Judge.
Yes, NGT, we have decided.
No, there are dissimilarities in the matter. Those are not similar. This is a different case and that was a different case. Why say, my lord? There your lordship has held.
No, whether appeal lies or not against that order.
I am not on the point of law. Factually, lordship said, my lord, that may I place my lord's order?
No, which order you are challenging?
Whether exceptional circumstances is there or not in my case, that only I'll espouse my cause, my lord. Here is, in that case, in this Vikas Shwai case, WA 2051 of 23, my lord, there the issue was that
Sir, we are prima facie of the view. One view which we have taken in that decision, in that judgment, we are prima facie of the view that when appeal lies before a superior court.
I am not disputing your lordship. Your lordship is right. 200% right, my lord. I'm proud of that. Your lordship says unless there is exceptional circumstances to interfere in writ jurisdiction, maybe I'll have to go to Delhi. I'll go to Supreme Court. Oh, and what are those exceptional circumstances? Your lordship is mentioned also here. In my lord's judgment, at paragraph 17, your lordship, when an alternative remedy is available, my lord, that division bench order.
Please read.
A writ petition under Article 226 of the Constitution can be entertained only in exceptional circumstances.
Can be entertained.
Can
be. Doesn't.
No. That is your lordship's language.
Yes.
My lord, ultimately. Why I am saying, I'll take your lordship to further.
Yes.
Breach of fundamental rights, violation of principle of natural justice. In my case, there is clear-cut violation of natural justice. Why I say that, your lordship? Let me place this order, another paragraph of my lord's order. Last paragraph 24, my lord. As has been noted above, Mr. Behral and counsel appearing on behalf of the appellant has argued that without giving the appellant an opportunity of hearing, the NGT passed the impugned order such and such. Say order there record by direction. In the said order, the NGT has noted in paragraph 15 that none appeared on behalf of the respondent number 6, the appellant herein, nor was any counter affidavit filed, though the then, my lord, in the last paragraph, there was no exceptional circumstances before the single judge to have entertained the writ petition. Now, why I say the exception, why I'm claiming exception to this, your lordship, my lord, may kindly look at the cause title at page running from page 34, annexure 2, NGT order, my lord. There I am not a party. There I am not a party. I have not been made a party. No so cause was filed. No, nothing was served on me.
In the case we decided
that came in on 8/1/2024. I understand it has not been challenged so far, and it has reached its finality, Your Lordship. Now, my lord, the matter has been remanded to the NGT.
No, whether the law has been let down or not. Passing an order is different thing.
I'm not clear, Your Lordship. Your Lordship has laid down the law. But the Honorable Single Judge against the same order where the respondent number 18, he had challenged in a separate writ application, that came to be allowed.
So
my case was dismissed, though I had a better footing because I'm not a party there. And that respondent 18 was a party before the Honorable Single.
You are here before the revision bench.
That order is not challenged, my lord. Agarwal infratech order is not under challenge.
Are we bound by that order?
No, I don't say that. What I only beg to submit, my lord, that there are two conflicting orders as against the same. My lord, if I can't espouse my cause here, my lord.
By single judge.
By single judge.
Then you are here before us against an order passed by a learned single judge. You are challenging the legality of that order.
My lord.
There is a decision which says that if alternative remedy of filing an appeal before the Supreme Court is there, the court should normally not interfere except in exceptional circumstances. It can. It can does not mean it shall.
No.
Even if there is violation of principles of natural justice, you have remedy of preferring statutory appeal. Why the High Court should interfere? And your appellate forum is better forum.
Appellate forum, my lord, it is neither efficacious, your lordship. That is not there. But question is, lordship, I may look at this order. Honorable Single Judge order allowing the same application by filed by another, same against the same order.
That we cannot do.
Another
That we
aspect.
should not do.
Another aspect, my lord. The Honorable Single Judge has said, referring to section 14 and 15 of the Act, that tribunal doesn't have jurisdiction to direct for a criminal inquiry. So there also, by Lord said, they has interfered. Here in this case, only on the referring to paragraph 50, my lord, may kindly look at page 71. Should I place, my lord?
Please.
The state respondent shall also initiate criminal proceedings against the then Tahsildar such and such, and the then additional Tahsildar in charge, Sri Ashok Kumar such and such, concerned revenue inspector, revenue supervisor, and dealing assistant section officer. I am one of those persons. Straight away, my lord. As disclosed in the affidavit of the collector and district magistrate Nayagarh. Now, this district magistrate Nayagarh report was also not available. Neither was we are given any opportunity to say anything on that. So, on the basis of that, now criminal proceeding is also initiated. So, these are all exceptional circumstances. If your lordship agree.
Challenge. Now, filing any case before Supreme Court is easy. You can file petition from here. You don't have to go to any place.
Another aspect, my lord, is very difficult, your lordship, because already your lordship has passed an order. Now, in Radhakrishnan Industries case, your lordship, taking into consideration all these aspects, possibly that was, I am told it was placed before your lordship, maybe it escaped my lord's attention. Paragraph 27. The principle of law which emerges are that. Now, let me take your lordship to paragraph 26 first. Following the dictum of this court in
is the highest court of the land. Therefore, those whirlpool, and it's not statutory, the appellate authority, collector, the appellate authority is Supreme Court. The appellate court is Supreme Court.
Your lordship, if your lordship is not inclined to fear.
This does matter on 2 weeks. It will come after 2 weeks. 2 weeks for judgment. Heard.
Should I place those on record?
What?
Honorable Single Judge order.
What for? Do you know what are you submitting?
I am seeking parity, your lordship.
No. You are imputing.
No.
You are imputing.
No, this is.
Yes, this is what you are saying, and you are repeatedly saying.
That is, I never attempted.
You have been repeatedly saying that the same learned single judge passed this order, and this case passed this order. This is not the.
Anyway, your lordship, let me stop there.
If you can give your orders, we will consider.
My lord?
You can give those orders also, we will consider.
I will file it, my lord.
File it.
By way of memo, I will file it.
No, just sign it. Memo, you can just give the orders. That will be part of your submission.
Item 12.
Well, Lordship, 25 days delay, Lordship. Yes.
Yes. How much cost?
Has a Lordship, please, Lordship. Don't.
Yes, who is for the other side?
I am hearing for the,
Any?
where the rate appeal copy has not been solved. But
I'll
before
solve
going to
the-
that,
Item number?
where the PP
For order.
I would submit one thing before your Lordship.
Yes, we are allowing the
Yes.
limitation.
Condone the delay. I am also appearing for the respondent.
Yes, I am for. But then counsel for the parties, the appeal is barred by limitation. So there is 12 days delay in filing the appeal. So then counsel representing the respondents do not have objection to the
Condone the delay.
Condone the delay, but without recording consent.
considering the pleadings, explanation put forth in the application seeking condonation of delay, comma, the same is allowed. Delay stands controlled. Is this matter for admission? Under appropriate, under admission as first case, stop. Let copies of the writ appeal be served upon counsel representing the respondents.
Lordship, grateful, Lordship.
Item 13.
Item 13 on behalf of Mr. Palace for appellant minor. Minor, we have filed a requisite minor. AD has not returned money as per first list shows.
Defects have not been removed.
Minor defects are.
All right. Can we await service of notice? So, like why?
It was tracking report.
What is there?
Item received.
Received.
Yes.
Difficult to accept. Notices. Item received by whom? Yes. What should we do?
Tracking report shows item received. Item 13.
Someone is appearing for the other side.
No, we are for the appellant.
Appellant, there are two cases. 2887.
2887.
Then take fresh steps. Let fresh steps be taken for service of notice upon respond number 1 with one on correct and present address with his current and present address to registered post and last name registered post and speed post. The requisites for which must be filed within 1 week.
10, little more
10
than.
days.
Little more. Can we
Yes.
serve it to the lawyer, Manoj? Counsel appearing.
If he accepts, then we don't have any. right?
Well, we'll also try that. We'll try that.
Item number 14.
Grateful.
Broadly.
Wait, please, my lord. On the last day, my lord, your lordship said about that Jharkhand case. Lord, with the guesswork, my lord, what I believe that if it is the constituency of Khunti, the matter was before the Honorable Patna High Court. That has gone to the apex court. And that is known as Jaipal Singh's case.
Yeah.
If that is correct, my lord, I only by a guesswork, I found that it is in 72 Supreme Court 1840. But there, the lordships in the apex court, they found that the lady, by virtue of the marriage, assimilated into this customary things, and the panchayat also accepted. Therefore, the result of the election was also decided on that basis. But later on, after 78, my lord, by a series of judgment, as your lordship says, that by birth, if somebody is scheduled tribe, that will continue to be a scheduled tribe.
Do you have that judgment?
My lord.
Do you have that judgment?
No, I just found it on the, which has been taken note of, my lord, in one judgment of this honorable court, that I have got it, because that judgment is on Regulation 2 of 1956, where Jaipal Singh's case has been considered.
And that is under RP, Representation of People's Act.
Yes, my lord, that is a representation of People's Act. Khunti constituency. There, Horo, the lady named is Horo. Somewhere it is referred as Horo's case or Jaipal Singh's case. That is how it is. Jaipal Singh was the husband.
Yes.
My lord, now, so far as the first thing that your lordship wanted me to do by looking at the statute, since the explanation was there, indicated in the book, as I found that it has been substituted, all these provisions. But in fact, it's not so. As your lordship will find that I have got it, a copy, my lord, your lordship may kindly see that 1956 regulation, there section 3(1) was only there. There your lordship will find at second page, starting with notwithstanding anything contained in any law for the time being in force, any transfer of immovable property situated within a scheduled area by a member of scheduled tribe shall be absolutely null and void and of no force or effect whatsoever, unless made in favor of another member of a scheduled tribe or with the previous consent in writing of the competent authority. There was no proviso there in the 1956 regulation when it came. Then your lordship may kindly turn to the next flag. That is Regulation 1 of 66 by way of an amendment. Scheduled Area Transfer of Immovable Property by Scheduled Tribes Amendment Regulation 1965. Then your lordship finds that in section 3 of Odisha Scheduled Areas Transfer of Immovable Property Act Regulation 56, the following proviso shall be added. Then the proviso 1, then the next proviso is there. These are all existing now. Then your lordship may kindly see the next flag. In section 3 of the Odisha Scheduled Area,
No, but let us come to the decision. Forget these provisions. Come to the order passed by the learned single judge.
my lord, This is what I, my lord, humbly say, that your lordship wanted to see that these are additions subsequently made. And this explanation, my lord, which has been added, if I read it beforehand, my lord, permitted to do that. For the purpose of this subsection, a transfer of immovable property in favor of a female member of a scheduled tribe who is married to a person who does not belong to any scheduled tribe shall be deemed to be a transfer made in favor of a person not belonging to scheduled tribe. So by virtue of a deeming provision only, to see that exploitation of the scheduled tribe people, tribal people will not be there, this provision has been, it was there.
Of this explanation.
Explanation.
In section 3. For the purpose
May-
of this subsection.
May I read it again?
For the purposes of this subsection.
For the purpose of this subsection, a transfer of immovable property in favor of a female member of a scheduled tribe who is married to a person.
Section. Regulation, sorry.
Regulation.
Amendment.
76 amendment.
May I please, Lord, as you Lord. For the purpose of this subsection, a transfer of immovable property in favor of a female member of a scheduled tribe who is married to a person who does not belong to any scheduled tribe shall be deemed to be a transfer made in favor of a person not belonging to a scheduled tribe. Which otherwise means that a scheduled tribe lady, if she marries to a forward caste, in a forward caste, then permission will be necessary in that case, because it ultimately goes to the hands of that person of forward caste. This should be one kind of exploitation of the tribal people. That is the object behind this regulation 2. I'll be citing one judgment of this honorable court also on this score,
No,
on
but
the
this
point.
explanation is something else. No, let us understand. Who are you?
My lord, I am a scheduled caste, a scheduled tribe lady.
You are a scheduled tribe lady.
I filed an application before the authority that my land to the extent of 6.47 is under occupation of a person who doesn't belong to this scheduled tribe. Then that person who was in occupation of the land, he took a plea to have purchased the land in the name of his wife. And that wife, my lord, belonged to scheduled tribe. So the question comes, if a scheduled tribe lady had married to a person of forward caste, will she continue to be scheduled tribe for the purpose of regulation 2 of 1956? I'm sure that she will always be scheduled tribe. But for the regulation 2 of 1956, my lord, because the object behind it is to see that exploitation of the tribal people should not be there. That is the reasonings given by this honorable court, my lord. I will take your lordship to one of the judgments also.
What is the date of transfer?
Date of transfer, what he says, it's 1964. And later on says that to have obtained a permission regarding a part of the land for sale after 15 years.
Just a minute.
Oh,
There was a scheduled tribe lady. You are scheduled tribe lady.
yes, my lord.
The land was transferred to a scheduled tribe lady.
Yes, my lord.
All right.
Yes, my lord.
Was married to
Oh, bless, my lord. That's the fact.
right.
My lord.
So this explanation will have no application.
This explanation will have application because, my lord, I am coming to that.
Yes, yes.
My lord, I am coming to that. Let us read, my lord, again that proviso. My lord, explanation, my lord.
Explanation we will not read. We will not read because
My lord,
it came into force from 1977.
my lord, that also.
So this explanation will not declare a transaction prior to that null and void.
My lord, I'll try to.
What is the question of why should we read explanation?
My lord, for this reason, because your lordship knows I am passing on to your lordship's few judgments are there also, but the gist of it is that if a particular statute is amended and an explanation is added to it, starting from the Bengal immunity case also, the question would be that whether it will be deemed to be there in it or not from the day it commenced.
Don't complicate this simple issue
My lord,
so much.
Maybe, my lord, but the question of law, my lord, that has been dealt with in several cases, including one of the judgment of this honorable court.
Please read that the amendment that says it shall come into force at once.
My lord, even in that Bengal immunity case also and several other judgments.
Sir, can you imagine a situation where all the transaction prior to 1977 can be held to be null and void on the ground of subsequent explanation in 1977?
My lord,
substantive provision. Explanation can also be substantive provision. If this is a substantive provision, that is
that will not.
That is prospective.
Here,
take away the rights of
my lord, here
rights already.
What my humble submission would be that your lordship may kindly have a glance, first of all, to the judgment of this honorable court, which has been reported in 1989, volume 2, OLR 580. It's a judgment of coordinate bench, taking into aspect this explanation, my lord, under the regulation 2 of 1956. This judgment is at your lordships at flag 7. This is the judgment, my lord, where the lady concerned, she was a scheduled tribe who sold it. And in the sale deed, she described herself as a person of general caste, that is Khandayat. Thereafter, this honorable court said that even if the caste was described otherwise, that will not be a bar to take into account that she is a scheduled caste.
If you are relying on this decision,
my lord,
can you tell us what was the date of transaction in that case?
This is not there here.
Not there. It is not there, then how can you rely on that?
Not there here. But if your lordship will kindly see from the next...
And this order was passed in 1982 after taking it into account 1977. Explanation.
My lord.
So 1977 explanation, in this case when the transaction was there, 1977 explanation was not there. How can you rely on this?
That's there. But here it doesn't say anything about that.
That doesn't say, then
but
you cannot rely.
If your lordship will see that what has been said also in the second page, in paragraph 4 towards the bottom, regulation has itself chosen to treat the sale and purchase by such a scheduled tribe lady differently from each other. The underlying purpose in both the cases is same, namely to provide protection against exploitation of scheduled tribe persons. In case of purchase, the regulation seemed to see thereof the transaction and lift the well thereof.
Disputing. No one is had this transaction been after 1977, the matter could have been different.
My lord, that would have been a straight case. But here, my lord, if your lordship will see I have also, your lordship may kindly turn to.
Even then, even in that case, Mr. Counsel, we could have differed with the opinion.
My lord, always it's.
But you cannot rely on this, in no case.
My lord, obvious purpose of the explanation to be added is always to find out.
Explanation cannot be read retrospectively. In view, particularly in view of the nature of explanation, it takes away the right which was available earlier.
My lord, vis-a-vis, the object behind the statute is to
object, Mr. Just think of the situation, the explanation. The provision says that a scheduled tribe person can transfer the land to another scheduled tribe person. There is no prohibition.
My lord.
Now, this is your submission that marriage will not change their status.
That's
This
true.
is your submission. Marriage of your opponent did not change because of her marriage. All right. So it could have been transferred to her in 1964. 1977 explanation says that if she is married to someone who is not, then it will apply.
That's the only contention that can I advance before my lord is that if
You
it is
have
taken.
already argued against
Yes.
yourself yesterday, or before when the matter was.
I said
taken up.
because it's a question of law, we cannot avoid that. We cannot mislead the court also in the point of law.
Sir, counsels
I,
like you, how can you mislead?
my lord, I only said before my lord that if it is treated to be, that's of course for your lordship's consideration. I have given few. Starting from Bengal immunity, then 91 Supreme Court, my lord, your lordship may kindly written notes at page 6.
Sorry, we have devoted much time.
My lord.
This matter.
Obliged, my lord.
2 बजे कुछ है क्या?
Grateful.
हाँ? अरे, tomorrow for judgment, court will. Or discuss for judgment tomorrow.
Item 15.
Yes.
Item 15.
Chair, yesterday.
I'm sorry I missed. Yesterday, I missed to tell the inquiry from the to take up the matter tomorrow. Because I realized after the meeting was over that this can you join today's interaction? We hope, Mr. Bashar, that the things are progressing.
Mr. Acharya is taking steps,
Yes.
talking to all
Yes.
concerned judicial officers.
Ma'am.
And they are also now taking up every day.
Ma'am.
Mr.
I think
Acharya?
after your lordships have taken up, I think there should be some improvement.
This is one. Now we can, since this matter has been taken up with all seriousness, we can leave that for the present. And then we can come to other aspects.
Yes.
All right.
My lords, in fact, if that I can draw your lordship's attention to my note, there are two jails. One is Jajpur and Bhadrak. If that note can be seen, I have given the problem of those two jails right from COVID period. Because if my lord can see page 3 of that note, I have given the previous orders, what has happened, that is page 3, point number B of that note for April 2024. I'm sorry, my lord, it's a bulky brief.
No. So you are referring to B.
B.
Overcrowding.
Overcrowding in subjail Jajpur and subjail Bhadrak. Now, if my lord would see this table, the first one is Jajpur. July 2020, the excess population was 66.91%. And then I have given the figures of across the board for October, November, right up to March 2024. Now, this jail has been consistently overpopulated for the past, if I can say, my lord, almost 2.5 years, 3 years, July 2020 onwards.
Yes.
Now, this is during a court monitored period, because all this while this PIL was being taken up, the court has also passed orders vis-a-vis these two jails.
No, but why has this gone down from 120.48% in June 2021
my lords,
to 31.34 in March 2024?
No, it has gone down because of one is this UTRC meetings and increasing of capacity, and this constant
capacity has increased.
Capacity has increased to some extent. Now the problems, the roadblock, because here the roadblock that we have hit now here is that there was additional capacities to be built and a new jail to be built. That is the subject matter of almost 10 orders, which my lord would see at page 8 of that note. I have given the order numbers and the dates. So almost 10-11 orders of this court regarding the increase, the direction to government to increase capacity regarding these two jails. Now, if my lord would see these orders and order numbers, repeatedly the court has been requesting the government that you increase the capacity of these two jails because nothing else can be done. Either the cases are of serious nature like POXO or in some other jails it's NDPS. So it cannot be reduced further. So my Lord Justice Raman would also recollect the last order, order number 49, dated 3/1/2024. There also this court directed. So now these two jails, they are not, we are not able to move ahead. Nothing else can be done except asking them to increase capacity on a war footing. And they are looking into aspects of mental health.
They assured that they would
They would
construct,
increase.
some other rooms.
But then the usual government red tapeism is there in so far as this. They have improved in other areas. I'm not saying that they have not done anything, but this probably they need to improve substantially more. This is one. Both the jails. Bhadrak also have given similar figures. The other issue would be that if what they have been doing across the state is this reduction, what fell from your lordships, one way of reducing the overcrowding is taking these people to a nearby jail. That as a temporary mechanism during COVID was approved by the court because there was nothing else to be done. But that on a long-term measure, that has impact in the sense that if they are away from their own homes or their own relatives not being able to visit, that would impact them. Then the local lawyers are also not very happy with this shifting. Suppose you shift them to 50, 60 kilometers away to another nearby jail, they also cannot have probably access to them. So this temporary mechanism of shifting them to nearby jail.
Lawyers go to jail.
Some of them
to visit.
Some of them go.
To meet.
To meet. So, but then this has been managed in the last 3-4 years. The majority of the management has happened in the manner of shifting. So if one prison is overcrowded, they shift it to a nearby prison.
So which is nearer to Jajpur?
Now, Jajpur, the nearest jail was Jajpur Road.
where whatever they could shift. But still then they are not able to manage. That's why I've given the figures for the entire period. So now increasing capacity on a war footing is probably the only way. That's why this court has also passed.
As you have indicated, order number 49.
My lord.
So pursuant to that order number 49, they have filed some affidavit. Mr. Mahanti has, as it seems on from the order dated 18/1/2024, they have supplied you a copy of affidavit.
My lord.
So
now they have to come back with a concrete proposal regarding these two jails that they have now targeted
the affidavit. Whatever you stated.
If I may. Well, there are two jails, my lords, which, my lords, the amicus, amicus said. One is, my lords, at Bhadrak and the other is at Jajpur. With regards to, my lords, the Bhadrak jail, there has been an increase of 180 wards because there's a new jail that has already been constructed and it was completed in March 2024. In our last affidavit also, we had indicated that it will be completed in March 2024. It has been. So the figures that has been provided by the learned amicus.
No, have you sifted the inmates?
Because it has been completed, I will take, because it was completed only in March, so it is April. So the shifting, whether shifting has happened physically or not, my lords, I will take my lords' instruction. I would seek my lords.
You will have to tell us tomorrow.
Please, my lords.
Because every day you are violating the fundamental rights. There is violation of fundamental rights every day. If you are having inmates beyond its capacity. So since you have constructed jail premises, you will have to expedite the process of shifting. And you should not wait for inauguration or these formalities. Their fundamental rights are more important than such functions.
In fact, overcrowding also puts a pressure on the jail authority.
Tell us tomorrow.
Please.
Tell us tomorrow. We will take up the matter as on priority basis tomorrow.
Please.
Tell us at 10:30.
Please.
About the shifting.
About the shifting.
Mr. Mahanti, on 3/1/2024, we have reflected the additional IG of prisons, his letter. Then we have directed you to file at para 6 of the order to undertakes to produce the detailed information about the, you have undertaken to produce the detailed information about balance project, which is required to get administrative approval and the timeline fixed for completion of the work. Such affidavit shall be filed by 17th January 2024. As it seems, you have filed an affidavit and order
on 17th of, yes. 17th of January, we have filed one affidavit.
18th January, the order is passed that you have filed the affidavit and served a copy on.
Well, in that
so that timeline and other aspects, Mr. Gautam, have you?
Well, I have now that affidavit gives a timeline up to 2027. So now they have to say that what will they do with this excess prisoners till 27? These people can't wait till 27 for additional capacity to come in.
No, if I may, Millers, that 2027 is for the second phase construction. My instruction at 180 ward jail has already been completed, which was in the first phase. In the second phase, Millers, there were other works which were to be undertaken, like the residential houses. If my lords may take the affidavit filed on 17th of January, page number 8 of my affidavit.
Yes.
We have given a detailed.
That is flag 139.
If required, we can constitute a team to visit all jails. Condition of jails.
What I was trying to tell your lordships is Bhadrak and Jajpur, they will additional, they have given a timeline which they would adhere to. It will take some time. But till then, they must have some arrangements so that it's within limits. Because here, the intervention of the legal aid, the board and everything, that has already worked its way. We cannot reduce it further. That's why the figures from 2020 onwards would may be relevant. That nothing more can be done. This was during the court monitored phase. So till the additional capacity comes up, you have to have something for this kind of overcrowd. That is what I was trying to convey to your lordship.
Yes.
Since the first phase is over and there is millets at Bhadrak.
Tell us tomorrow whether you have shifted the inmates
whether
or
we
not.
have shifted.
First of all, we will take up the overcrowding issue. So after that, we will take up overcrowding issue first, and then we will go to other issues.
Please.
Tomorrow, tell us.
Please.
Because it is your statement that the jail has been constructed. Whether the inmates have been shifted or not, you don't know.
No.
Have instruction.
Please.
And if they are shifted, Mr. Mishra, then to a great extent,
Bhadrak would be resolved.
Because Bhadrak, the scheduled capacity was 201 and the excess inmates are 63 in number. So if this 180 ward jail is ready, therefore there wouldn't be any overcrowding.
Bhadrak, but Jajpur.
At Bhadrak. At Jajpur, millards, there is a...
So you will have 2 jails in Bhadrak?
Millards, this is a new ward in that jail. There is a new
ward.
New ward.
All right.
We have additional wards. And with regard to Jajpur, millards, the work is undergoing with regard to creating an additional ward of 50 ward jail.
Where?
At Jajpur, where millards, we have given in an affidavit that it is slated to be completed by 31st of May 2024. That is also in our affidavit of 70.
But in many cases, you have some dispute with your contractor.
Please, millards, whereas those
disputes.
Yes, millards. There are those because they are contractual work. And
all right, we will see tomorrow, Mr. Mishra.
I beg pardon, my lord. Item 16, next item. I pray my adjournment for next week on it.
Let me the second 16. When?
On next week or 1 week after, because Mr. Bose is not well. So.
But Milan Senior, Mr. Monty and Mr. Patnaik will give the reply.
If I can put a request, man. That item number 23, which my learned senior is mentioning, it can be taken up sometime next week or Monday, Tuesday.
Lordship, I am in the serial number 1. I am ready with the brief, Lordship.
No, my only problem is that we have fixed cases.
Right.
Almost on each and every day at 2 p.m.
Right.
The matters which are important and which require hearing.
Correct.
So we may not find a date. So
Lordship, all my clients are on the verge of retirement.
The virus matter.
Virus matter, you are not concerned with my case.
So far as my matter is concerned, that was the leading case which your lordship have fixed the judicial order has been passed. With Mr. Roth, in fact, he is in difficulty. I have no.
You are for whom?
I am in the serial number 1 in item 23.
For
the petitioner.
I will hear you.
Lordship.
Let this be concluded.
Lordship.
We cannot deny hearing.
Absolutely.
Lordship.
In that case,
We will see. We will see.
Right.
You batch case?
Batch case, the matter where lordship have fixed that that is the lead case. Lordship already had lordship predecessor. I can begin it, then lordship will fix it.
Item number 17.
Please, your lordships. Lord, yesterday I had taken your lordships to the order that was passed, which is the impugned order. I'll just point out 3-4 paragraphs from IDCO's reply, which is the principal opposite party. If your lordships can have a look at the counter which has been filed by IDCO, which starts from page 37 of your lordships.
Page 37.
7, yes. From
27 or 37?
Page number 30.
37.
Yes, my lord. 3737. Lord. That's the counter affidavit filed on behalf of OP number 1, which is IDCO.
Yeah.
If your lordships would come to para 9 at internal page 3, running page 39.
Yes.
Lord, the last 4 lines of that, because that has been their endeavor to show to your lordships that it has been my voluntary act of acceptance of 142 acres. On the request of the petitioner, government land of acre 142.12 have been allotted in favor of the petitioner and possession was handed over. The petitioner was at liberty not to take over possession of the said land. As if to say that 226 acres is a misnomer. There is nothing which is binding to 60 acres or anything. It is 142.2 only. Then your lordships may come to page 41. That is paragraph 12, which starts from page 40, but I'll just take your lordships at page 41. The relevant portions I'll just point out, my lords. Not more than that.
Yes.
If your lordships would come to the the 5th line from the top, the government in steel and mines department, if your lordships got it.
Yes.
The government in steel and mines department, while later dated 29/4/2006, intimated IDCO that the administrative approval for acquisition of private land measuring an area of acre 64.65 for the proposed integrated steel and ferroalloys project of Messrs. Deo Mines and Minerals, which is the petitioner, has been accorded on the condition if it is felt at any time to delete any portion of the area, the same shall be deleted from the purview of land acquisition. So this is their admission that in 2005, they had initially sought to cancel my lease, which was later on they accepted my explanation. And then they themselves say in 2006, the government has given them the administrative approval to acquire that land. The additional land of the private land and the additional land, government land, some 54 acres, which is I showed on the last occasion to your lordships from their own letter. Then your lordships may come to para 15 at page 43. Lordships.
Yes.
The last 6 lines, it starts with, it is also stated, if your lordships would come to the end of the page, last 5-6 lines.
Yes.
It is also stated that they have planned for completion of the project by June 2015 to June 2016, subject to obtaining the required statutory clearance in time. It is also stated that the project cost will be around so and so amount, rupees 405 crores, and will generate employment for approximately 4,000 people.
They have also stated for earliest allotment of balance 117.88 acres of land to enable them to complete the project in time. The petitioner company have also furnished an undertaking as per the direction of the Honorable High Court in WPC number so and so. It is not a fact that the issues raised in the petition were considered. I don't know if it is a typographical error that it has not been considered, but they say that it is fact that it has been considered.
Yes.
Then your lordships may come to the next page. Lord, last paragraph of para 16 at page 45.
Yes.
Starts with Measure Sam Steel Industries Limited. Lordships got.
Yes.
Sam Steel Industries Limited have filed SLP C number so and so against Devmines and others challenging the judgment dated so and so, passed in WPC number so and so. The Honorable Supreme Court vide their order dated 19/7/2012. I just wanted to point out this date. Passed in SLP so and so, directed that there shall be stay operation of the impugned order of this Honorable Court. Now, if your lordships would see, just to come back to the impugned order, which is under challenge, which is, my lord, at page 16 or page 15.
Yeah.
If your lordships, just page 15, if your lordships would see, the forwarding later along with the order. That is dated 16/6, but in the body of that letter, what they have mentioned. I am directed to inform you that the chairman cum managing director, IDCO, after careful consideration of your representation dated so and so, and subsequent discussion with your representative on 12/6/2012 and taking into account the materials on record, has rejected the same on 12/6/2012. So the earlier writ petition, the direction which was issued, stood acted upon on 12/6/2012. And the stay order was passed in July 2012, which was subsequent stay order. So which, of course, my lord, my learned senior on the last occasion stated that that cannot be gone into, but that has already been acted upon. So IDCO cannot have a grievance so far as the earlier writ petition is concerned, because whatever the directions have been issued, and they have not challenged the direction. IDCO itself took up my representation and rejected it on 12th, communicated to me on 16th, and the Honorable Supreme Court passed the order on, my lord, that is the date I just pointed out, my lord, 19/7/2012. So the entire, my lord, issue, I'll just sum up to say that this 260 acres, which is a very focal point of the litigation or the issue, that was the requirement which was assessed not by me, but in consultation with EPCOL. IDCO being the authority appointed by the government to acquire the land and give it to me. That is their limited scope. So they were supposed to give me 260 acres. The original where it was planned, that could not be given. In the alternative area that was chosen, they gave in 2 phases 142 acres. After that, even though they got the approval to acquire, there were government land of 54 acres and administrative approval was there for rest 64 acres. That is in total, my lord, about 118 acres. They did not take any steps to acquire that land or to give it to me. And they come back with saying that I am not serious about the project. And the reasoning which has been given that I have not started any progress on the production. So the entire endeavor has been to frustrate this MOU and the allotment order by not adhering to their part of the promise and shifting the blame to me. And on different occasions, at different stages, they have taken prevaricating stands. Initially, they said that this 142 is the bottom line. Then they said that, okay, rest will acquire. Then they sought for the administrative approval. Administrative approval was given. They never came out with the 4-1 notification, which has been also written by them to the government. So the conduct of IDCO, insofar as rejecting my representation, is, my lord, illegal. That's my submission. Deeply obliged, but
Mr. Patel, you unmute.
I am just, your lordship would kindly see the rejection of the representation under Annex 1 is the subject matter of this writ application. That is the impugned order before lordship, which was read over to your lordship yesterday by my learned friend. And your lordship would kindly see the direction of the division bench judgment matter. A little background is necessary to tell your lordship that IDCO has cancelled the allotment of 142 acres, my lord. After cancellation, my lord, they came up before this honorable court. And my lord, this in the judgment, my lord, that cancellation order was set aside by this honorable court, which is now pending before the honorable apex court, my lord. My lord, that is the background, my lord. Your lordship would kindly see, in spite of the stay order by the honorable apex court, the honorable apex court has directed that this writ application is to be disposed of by your lordship. Your lordship the other day asked us, what is your submission regarding this? Then in spite of the stay order, if there is a direction to this honorable court dispose of the matter, what is the suggestion of your lordship categorically asked me, my lord? My lord, my submission to your lordship is that this limited scope of disposing of the representation shall be disposed of by your lordship, whether it was rejected justly or not, justified, it was justified or not, my lord. That is my endeavor to submit before your lordship. My lord, I think I am clear, my lord.
Yes.
My lord, your lordship would kindly see the direction in the judgment, my lord. That your lordship would be confined to the direction in the judgment, my lord. Your lordship kindly see the judgment of the division bench, my lord.
Which page?
Page 35, my lord.
of the earlier judgment, my lord, not of the brief.
Earlier judgment, my lord.
The judgment which was passed in WPC 19252 of 2010. The earlier writ petition.
Is that there on record?
Yes, my lord, it's there on it.
Where?
So lordships, I can give a physical copy of it just for your lordships.
Your lordship need not go to judgment. Your lordship kindly see paragraph 14 of the writ application. That is at
2010.
2010, yeah.
That is at page 8, my lord.
Yes. You want us to see paragraph page 14?
Page 35, my lord. See.
Page 35.
Of that judgment.
Yes, my lord.
Yes. Yes.
My lord, from paragraph 58, my lord. Having answered all the contentions points in favor of the petitioner company, we allow the writ petition by passing the following order. The impugned order of cancellation dated 30th August 2008 is hereby quashed by issuing a writ of surcease. Although the quashing of the order of allotment and lease deed executed in favor of opposite part number 3 is not sought, they will not survive as you have restored the allotment of land and the lease deed executed in favor of the petitioner company. Hence, the same are hereby quashed by issuing a writ of surcease. It is open to the petitioner. Now, my lord, the last direction that is being adjudicated upon by your lordship. It is open for the petitioner company to give positive undertaking to the corporation that the terms and conditions of the allotment of land and the lease deed will be meticulously implemented within a reasonable period of time that may be considered reasonable by the corporation to its satisfaction. If there is valid explanation by the petitioner seeking for extension of time, which shall be conveyed by way of representation to be filed within 2 weeks from the date of receipt of this order, the same shall be considered and appropriate order shall be passed thereon within 4 weeks thereafter. It is if the time is not extended, this is important. If time is not extended by the corporation, as observed above, being not satisfied with the explanation, seeking for the extension of time for commencing the work and production, it will be open for the corporation to take necessary steps to cancel the allotment of land in favor of the petitioner and execution of the lease deed in respect of the land in question by following the procedure as provided under the Act 1900, that is IDCO Act, my lord, and the OPP Act, that is Public Premises Eviction Act, my lord. So this was the direction, my lord. Now, my lord, in the impugned order, IDCO considered whether the extension of time for completion of the project can be given or not. That is being challenged by my honorable friend in the writ application. Your lordship would kindly see in the result, in the impugned order, my lord, these things have been categorically written, my lord. Your lordship would kindly see that possession of acre 120, my lord, was delivered on 27/2004, and balance 22 acres, my lord, was handed over. Possession was handed over on 18/1/2005, my lord. Your lordship would kindly see 2 letters which are important in this connection. What was the terms of allotment, my lord? Your lordship would kindly see rejoinder. Our counter, your lordship was just saying, OP, that is IDCO's counter, my lord.
Yes.
My lord, there is only one annexure, my lord. That is A/1.
Page 47.
Page 47.
Yes.
Your lordship would kindly see, we acknowledge with thanks the receipt of your above mentioned letter for allotment of 120 acre of government land in village such and such under Banai Tahsil for establishment of our proposed integrated steel and ferroalloys project. Would like to convey the acceptance of all the terms and conditions of your allotment letter and request you to kindly defer the date of submission such and such towards cost of the land to 15/7/2004 as our Director of Finance is on tour. They have accepted all the terms and conditions. And your lordship would kindly see, they have filed a document in the rejoinder, my lord. I am sorry to, my lord, take your lordship to various, my lord, rejoinder, which has been filed by my lord friend, my lord. Yesterday, your lordship was looking at it, my lord. My lord, rejoinder internal page 12, my lord.
$170.
170.
172, my lords. Running page.
I am sorry, my lord, I am not designated accordingly.
No problem.
Annexure 6.
Annexure 6, my lord, page 12.
That 172.
Yes.
Request for allotment of approximately 120 acres of land at village Thaibarana under Banai subdivision of Sundargarh district as an alternative site in lieu of 260 acres of dairy farm land at Kuaramunda in Sundargarh district for a proposed integrated steel and ferroalloys project. According to the earlier proposal, it was considered by the government of Orissa for allocation of 260 acres of land at LPT farm Kuaramunda in Sundargarh district as incorporated in the MOU signed on 1/1/2003 for establishment of our subject project. Since the government has now approved the location of a medical college at the above site, we request you to kindly arrange to allot us an area approximately 120 acres of acres at village Thaiberana under Bonai subdivision of Sundargarh district, readily available with us to enable us to commence construction of our proposal project, my lord. To meet the balance that, then your lordship kindly come to Annexure 7. My lord, they said that we will start our construction if you give us 120 acres of land. My lord, in that rejoinder, your lordship kindly come to Annexure 7. Internal page, my lord. 13, my lord. That is our letter, my lord.
173.
Yes, my lord. I'm sorry. 173.
Yes.
My lord, with reference to your application dated 16 to 2004, recommendation of ethical and subsequent decision of government to change location of the project from Kuaramunda to Thaibarana under Bonai district, Tahsil, we hereby allot government land measuring in the area of acre 120.1 to village Tarivonia under Bonai Tahsil in the district of Sundargarh, more fully described in the schedule below in your favor for establishment of a project for integrated steel and ferroalloys project on the following terms and conditions. Your lordship kindly come to page 15, my lord. Internal page 15. In that letter, my lord.
Yes.
My lord, paragraph 13, your lordship kindly see. You will have to start the civil construction on the allotted land within 6 months and utilize the land and start commercial production within 2 years from taking over possession. That was the terms given to them, my lord. And they also accepted it, my lord, as I showed to your lordship. So making a construction within a period of 6 months and completion of the project within 2 years have never been questioned by them that we cannot do it, my lord. Then your lordship would kindly see their entire acre 260, my lord, was required for medical college. And we have been trying our hard to to process, my lord, various aspects, my lord, of the land to give them whatever additional land would be necessary, which we are doing, my lord. But in the meantime, my lord, your lordship would kindly see 260 acre 260 land was the result of a MOU with the state government, my lord. And my lord, that MOU expired in 2005, my lord. My lord, again that was extended for another 2 years, which your lordship would get it at my paragraph 6 of my counter, my lord, which was just placed before your lordship. At page 38, my lord. Page 38 of the running page, my lord, which my lord and placed, my lord. Paragraph 6, my lord. That in reply to the averments, made in para 3 of the petition, this deponent humbly submits that the MOU was signed between Government of Orissa and Deomines Minerals on 1/10/2003. The MOU was valid for a period of 2 years and was subsequently extended from 1/10/2005 to 31/10/2007 for a further period of 2 years. Thus, it is not valid and subsisting till date, my lord. So 2007, my lord, it lapsed, my lord. And your lordship would kindly see what happened in the meantime. We asked the petitioner, my lead petitioner, that you submit us the progress of the civil work, my lord. Your lordship kindly come to page 39, paragraph 10, my lord. That in reply to the averments made in para 8 of the petition, this deponent humbly submits that IDCO by letter number 8195 dated 2/6/2005 and subsequent letter number 9056 dated 21/6/2005, 2 letters, matter, requested the company to communicate present progress of civil works, which were to be completed within 6 months for further action in the matter. Finally, IDCO issued a notice on 7/12/2005 to the petitioner company to submit the progress of the plant within 15 days, telling which allotment shall be deemed to have been cancelled for breach of terms and conditions of the allotment. That was the notice given to show us, to intimate us the progress, which it was not satisfactory, my lord. In reply to the averments made para 11, my lord, that in reply to the averments made in para 9 of the lead petition, this deponent humbly submits that the petitioner's reply dated such and such to this opposite party's letter on 7/12/2005 was not satisfactory. IDCO allotted an area measuring acre 120.12 of government land in village Thaiberna in the district of Sundargarh in favor of the petitioner for establishment of the integrated steel project in its letter. The petitioner company accepted all terms and conditions of the allotment, which I have already placed with your lordship. My lord, your lordship kindly come to page 41, my lord. The last paragraph, my lord.
Yes.
It is also relevant to state here that the collector Sundargarh, by letter number 1458, dated 21/5/2008, intimated that the land allotted to Messrs. Deo Mines and Minerals Private Limited has not been utilized and the company has not started commercial production even after 2 years of allotment, with a further request to cancel the land and evict the company therefrom. A writ petition by such and such was filed earlier by the petitioner to set aside the so cause notice dated 30/8/2006 issued by the government Steel and Mines for termination of the MOU, and the same was dismissed by this Honorable Court such and such matter. Then your lordship would kindly see, that will be my last document to show to your lordship, that your lordship had directed to apprise your lordship about the status of the present land, my lord. That I have filed at flag 60, my lord.
But the
Flag
whole
60, my
case,
lord.
Mr. Patnaik, the entire
Yes,
case of the petitioner is based on the plea that for the said project, 260 acres of land was required. 260 acres of land was allotted to him also. Approved. Subsequently, 142 acres of land was
Yes,
allotted to him.
Yes, ma'am.
So, is this your case that whatever was allotted to him
Yes, ma'am.
below 260 acres
Yes.
was sufficient for him to establish that project?
Yes, my lord. That's my case, my lord. And your lordship would kindly see, not
No,
even
but
a
who can
big-
say this? Who can say? Only an expert can say. Only your whether is there any technical scrutiny of this? that
My
on that piece of land,
No, my lord,
despite the fact that
my lord, I may be pardoned, my lord. With respect, I will say they accepted it, my lord. That 142 will establish the project, my lord. That is what I read before your lordship. They accepted the terms. They could have said, and your lordship would be surprised to know.
you may submit that they accepted only to the effect that they can proceed with the construction.
Yes, my lord, I am obliged.
But not that that land is sufficient.
Yes,
for-
my lord, that may be. But they did not progress anything, my lord. And your lordship would kindly see at flag 60, my lord, my affidavit, my lord, pursuant to your lordship's direction.
But
Flag
was it not your duty to convey to the petitioner that yes, this land we will be providing 260? There are two aspects. You can take a stand that 142 acres was sufficient for him to establish the project, which he did not. Or two, you had conveyed to him that we will give you 260 acres of land. In the meanwhile, you please start your
Second,
construction.
I will rely on the second point that your lordship indicated. That is the thing, my lord. That is also true fact, my lord. And your lordship would kindly see at flag 60, my lord, that affidavit pursuant to your lordship's direction in 2023. 6/2/2023, my lord.
No, but Mr. Pattaya, it's a very huge investments are required to be made in such projects.
They have not done even my lord, they have not even put a brick on the land. Not even a brick.
Why should they? If they are not sure that they will be getting sufficient land. That is the question.
They should have withdrawn.
So we withdraw, yes. Why did you cancel? Withdrawal is something. Cancellation is taking away.
Yes, my lord, cancellation, my
He
lord.
might have withdrawn.
My lord, I will show to your lordships from the judgment. This giving of additional land was not an issue in the last writ application, my lord. That your lordship should kindly see at page 20, my lord, of the judgment, my lord, at paragraph 42, my lord. Your lordship kindly have a look. What were the issues?
Page 40.
42, my lord.
Para 40.
Para 42.
Para
Page
42.
Internal page 20 of that.
Yes, please.
Your lordship kindly see paragraph 42, my lord.
Yes.
With reference to the above said rival legal contentions, the following points should arise for consideration by this court, my lord. This was the writ filed by my petitioner, my lord. Whether the impugned cancellation order dated 30th December 2008 is passed by the competent authority of IDCO and constituted under section 42 of the Odisha Industrial Infrastructure Development Corporation Act 1980. That was the issue, my lord. Then your lordship would kindly say whether the cancellation of allotment of industrial plot 142 such and such in favor of the petitioner on the basis of the so-called notice dated 7/12/2005 without issuing further notice and hearing the petitioner is illegal and valid.
Yes.
Whether the so-called notice was subsisting in view of further opportunity given by the corporation by its letter dated 18/1/2006. Whether IDCO has taken possession from the petitioner company after resumption of the land in pursuant to cancellation order. Whether the allotment of land and execution of the lease deed in favor of the opposite number 3 without taking over possession from the petitioner company is legal and valid. And what order? Well, this was never an issue That's cancellation of allotment without giving them sufficient land or surplus land is a valid reason, is an invalid reason for cancellation. That was never an issue before the, so this is the petitioner is the read petitioner here also.
Oh, plus, please come to paragraph 5.
Well, those are all contentions, my lord.
Contentions, the questions were framed in the light of the contentions which were raised.
Yes, my lord, but this issue was not framed, my lord. Whether we should have given surplus land in order to complete the project or not. That was
So
never an issue.
According to you, that aspect has not been decided.
Yes, my lord.
And should be decided by this court.
No, my lord, your lordship would to see.
There are two aspects. There are two aspects. One, you can say that this issue was also decided or was subject matter of the writ petition, earlier writ petition, or you may say that that aspect was not gone into and therefore this court should go into that aspect.
No, my lord, my submission.
Or you can say that this plea was available to him.
Yes,
not taking...
that's my constructive res judicata, my lord.
All right.
It is a constructive res judicata. Your lordship may see the affidavit. That will be my last submission to your lordship, my lord. At flag 60, my lord. Your lordship kindly come to flag 60. 60, my lord. Sorry to trouble your lordship.
Flag 60?
Yes, my lord.
Is there any flag 60? Bottom.
In the least, my lord.
Yes.
Your lordship got it?
Yes.
Your lordship kindly see paragraph 2, my lord.
Yes.
This was filed on 4/1/2004, my lord, recently. That pursuant to the order of this honorable court, dated 6/2/2023, I am hereby filing the current status of the land in question. That pursuant to your lordship direction. That pursuant to the order dated 6/2/2023, an officer of the opposite part number 1, additional land officer IDCO, Sambalpur division, Sambalpur, was deputed to carry out a field survey and submit report with regard to the present status of the land in question for allotment. That as per the report, my lord, submitted by the additional land officer Sambalpur, it was found that the land in question is lying vacant, which was acquired by IDCO, measuring an area of 142/12 village Taiparna under Lavanipada Tahsil in the district of Sundargarh. And it was further submitted in the report that there was no industrial construction made over the said land. However, it was reported that at present some people are unauthorizedly occupying, and that's not relevant. But so this is the last report, my lord, about the land. Yes, now it has been put a brick, my lord, over the land, my lord. So therefore, the cancellation order under the representation was rightly rejected by IDCO in Annexure 1, which is the impugned order before your lordship. That is my sum total of the submission. Yes. I complete, my lord.
Thank you. Yes. Mr. Raman.
My lord, just that, can I add something? My lord asked a very question that why that cancellation happened at all. Whether it was because of the land, the entire land was not given, or for some other reason, my lord. My lord, if my lord will see for the allotment for a moment. I'm just reading it out for my lord convenience. My lord, one of the conditions in the allotment letter was that you will have to start the civil construction on the allotted land within 6 months and utilize the same to start commercial production within 2 years from taking over the position. So my lord, there was not a single, they never started the construction. And if my lord, for that reason, because they never started the construction, even whatever land was there for them, they never started the construction. It is not their case, my lord, that they will get the entire 260 and they will start the construction. Because they can complete the construction after getting 260. That is a different issue. But they never showed any progress of work on that land. Secondly, my lord, in our cancellation letter, we have verily written, my lord, that it was also stipulated in the allotment letter that you will start the civil construction on the allotted land within the 6 calendar months, and utilize the land and start commercial production within 2 years from the taking over the physical possession. My lord, regarding the first part, that you have to start the civil construction, it was never done. And secondly, my lord, this allotment letter was accepted and a lease deed was also executed. So this stipulation in the allotment letter is sacrosanct, my lord. And that's the reason, my lord, when our rejection order was passed, the second rejection order was passed in 2012, they took a stay order, my lord. And that stay order is there, my lord. Just I'm reading it out. My lord, 36, 2012, there was a stay order of this scope, my lord, of our impugned letter that has been annexed, my lord, in the writ application. After that stay order also, my lord, that's the reason, my lord, why we have filed this affidavit, saying that they have not done anything till regard, they have not started even the civil construction. Now coming back to my lord.
So when was the order stayed by Supreme Court?
My lord, it was Supreme Court order, my lord, was after 13/7/2012. 13/7/2012, my lord, the first writ petition order was stayed, my lord. That impugned order was stayed.
Therefore, after 2012, nothing could have been done.
Right. Now, if my lord, I'll go to their letter, that authorization letter and the letter that they gave us for consideration of their case, which was rejected by us, my lord, if I go to that letter for a moment.
So you cannot blame them for any lapses on their part.
After 2012, my lord, I admit, I bow down that I cannot blame them. But when this land was allotted to them.
When was the writ petition filed?
Writ petition was filed 10, my lord. Writ petition. First was 10.
Just a minute. From 10 to 12 also, you cannot blame
my lord. No, my lord. After 12 also, after the order of honorable Supreme Court,
from 10 to 2024, he is not to be blamed.
My lord. My lord, the period from 2004, entire time culminates from 2004, my lord. When that 2004, when it was allotted, it was specifically stated in the allotment letter, which they have accepted, whole and soul, my lord, that within 6 months, they have to start a civil construction. That is, my lord, the main focus. Now, my lord, coming back to their representation and undertaking, I'll just point out, my lord.
So whatever is being submitted before this court has already been addressed by division bench.
That is, my lord, has been addressed by the division bench. My lord's query was that whether they should entire land was to be provided them to complete the project, or they have to start a civil construction. Because this 142, my lord, land was available to them or made available to them, their own letter says that we will start commencement of construction, my lord. That is, my lord, letter, my lord, where they say that since the government has approved the location of medical college as above site, we request kindly to arrange and
let us see the impugned order first.
Yes.
Starts from page 16 of the writ petition. 15 is the forwarding letter and 16 it starts.
So this order has been passed pursuant to judgment dated 24/4/2012 in WPC 19252 of 2010, which has been stayed.
has been stayed.
So what will the court decide?
Then, my lord, now court has to, my lord, that is what I am to submit, my lord. 2008, the cancellation of allotment was challenged.
Mr. Please appreciate this, the scope of the present writ application. The effect of the order passed in WPC number 1252 of 2010 is that the order of cancellation has been set aside with certain directions. All right. Now, that order has been stayed. So the judgment has been stayed. Now, this order has been passed in the light of the said judgment. Then what can we decide? Everything has been decided in that case.
Now, my lord, if my lord, the fallout of that thing is that only the impugned letter of 2006, those, whether it is in the legality of that letter can be only be tested by this.
2000, everything was there. All the matters were there.
The letter rejection order. After the first writ court order, my lord, second rejection order was passed. Because
second rejection order is of which date?
My lord, it is 16/6/2012.
This is what we are saying.
Yes, ma'am.
That this 16/6/2000 order has been passed in the light of
earlier direction.
This court decision.
Yes.
Which is stayed.
Yes, which has been stayed.
So on that ground we can cause the order.
My lord, with that ground, because
No, my lord, it cannot be caused, my lord.
Yes, it cannot be so caused, you're right.
No, but the question is, my lord,
What I was
may I just interrupt, my lord?
very first day.
May I be pardoned, my lord?
Yes,
My lord, my
can you wait?
submission.
Can you wait for some time? Mr. Patnaik will revert back to you. Please wait.
Yes, my
We
lord.
will come back to you. Let them
Yes,
come back thereafter.
yes, yes, ma'am.
So we have.
But what I find, I told your lordship in this, exactly in this way, that what troubles me is that the Supreme Court has already granted a stay of operation of the judgment. That means the operation of the judgment was, operative portion was paragraph 54 and 55 of that judgment. Well, may I take the trouble of bothering you again?
Oh, yes,
and again?
please.
Your lordship, may I take your lordship to paragraph 50? But what was the, let us first see what was the ambit and scope of the earlier writ application, 2010 writ application. Because this order is an offshoot of that judgment of that writ application.
Had this order been not there, had the decision of the High Court been not there, this order would not have been passed, which is under challenge in the present writ application.
Yes. So the earlier, what I meant to submit is the earlier the ambit and the scope, both ambit and scope of the writ application order. What did they challenge?
Now just think of a situation if this order is set aside by the Supreme Court, then what will happen?
But the entire endeavor is useless. But if that that judgment is set aside, then the allotment goes and the lease goes.
Then the writ petition becomes useless.
Yes.
Which we are considering. Yes.
That is what I submitted in the very past.
In view of the above, that means this case is pending. In view of the description as expeditiously as possible and quickly. So
we
can just decide.
And that one permission to place additional documents, issue notice, and in the meantime, meanwhile, there shall be stay of operation of impugned order of the request. So this 2010. That is it.
So we are in a cash to.
So you guide us.
Cash to.
You should guide the court.
Well, what I am telling you, Lord, what I think when if the court is to proceed, how far it can proceed?
Can it? First question is, can it? And the second question is, if it can, then how far?
Remembers my initial submission is that I told that it is better to wait for the judgment of the Supreme Court and seek a clarification from the Supreme Court that in view of this fact, that matter has to be decided first, then only this can be.
Who shall seek clarification? We cannot.
Either we or them or them.
They are the petitioners before the Honorable Apex Court. And
Everybody is there, you know. If the ITCO can seek a clarification, they can seek a clarification, we can seek a clarification. No problem. State government can seek a clarification. All of them are before the Supreme Court. So
do it.
This is one aspect, madam. The second aspect is assuming that we have to proceed, madam. How far we can proceed, madam? There I have a suggestion. In order to know the ambit and scope of the present writ application, we have to go back to know the ambit and scope of the earlier writ application, madam. Earlier writ application, what was challenged before your lordship is the cancellation of the lease and the allotment order. Cancellation of lease and allotment order to the extent of what? That was confined to 120 and then 22. This means there are 142 acres where it was challenged. And it was never their case that no construction work could be done or could not be done because of the inadequacy of the land. Rather, your lordship sees paragraph 54 and 55 of the earlier judgment, my lord. Your lordship was holding it, my lord. The earlier judgment. May I be permitted to place this in law? Can I read it aloud?
Please, please.
Has your lordship got it?
Yes, yes.
The internal page 31 of the judgment, paragraph 54.
Yes.
In the instant case, the division under the head go is not appointed as the state of service. That is how I resort into the provisions. Then, my lord, paragraph 55. For the reasons stated above, has your lordship got it?
Yes.
We have recorded a finding on point number 4 in favor of the petitioner. The possession has not been taken over from the petitioner. What possession, my lord? That 142 acres. Because nothing more has been given to them at any point of time. It is alleged to be a paper possession which is not taking over actual physical possession of the allotted land from the company. Therefore, we have answered point number 5 that allotment of land made in favor of opposite party number 3 is without obtaining actual physical possession from the company as required in law, and also for the reasons assigned to point number 4, the land was not available for allotment as well as execution of the lease deed in favor of opposite party number 3. That is in our favor, my lord. That is against us, my lord. Then, my lord, therefore, question of execution of in favor of is not legal and valid. The fact that it was issued in favor of hence the allotment letter and lease are bad in law, that is in our favor. Having answered all the aforesaid contentious points in favor of the petitioner company, what order is required to be passed? It is an undisputed fact that all the have been answered in favor of the. It is also an undisputed fact that for the purpose for which the land was allotted in favor of the petitioner, company has not been put to use within the period stipulated both in the allotment letter and the lease deed. But here is the case law and executed in favor of the petitioner company. It is also an undisputed fact that so goes notice dated 7/12/2005 was issued by the corporation represented by the chief manager P&A.
Please tell us whether we have the competence to, just a minute, we have the competence to set aside the order.
But because the Supreme Court has again directed your lordship to hear this matter.
Therefore, we are saying that do we have the competence to allow the writ application?
No. Your lordship.
We should not. Because the
technically speaking, because of the latter Supreme Court directive to hear this matter, your lordship may proceed with it.
proceeding is different thing. But what are we? Can we decide?
What to do?
Yes.
The greater
Can we also? Not only should we, can we? Can we?
When I because the client's interest, I will tell that your lordship shouldn't. We shouldn't ought not to proceed.
No.
That was what I was telling your lordship past.
Yes, I remember now.
That is somewhat troubling. It's better to ask the Supreme Court for a clarification or send a report that in view of this contentious fact, this matter is awaiting the decision of this.
No.
That will be contentious.
We are not awaiting. We are hearing.
Hey, but what?
As the petitioner before the Honorable Apex Court, I think my learned senior's client can very well make an application to that extent. Because they have filed it and they have got the stay order so far as the earlier writ is concerned. And within the interim, this writ petition was filed after the disposal and prior to this passing of the stay order.
My dear friend, you have filed this petition here. Therefore,
No, but I have filed it prior to the filing of the SLP.
Now you are going to
Address us.
Lighter value. And the scope was the earlier interpretation also it was specifically stated that you give an undertaking as to when you will start the construction and
Let us see. Let us pass an order. Let us see what happens. Let us try. No, we are not disposing of the writ petition. We are just adjourning the matter with. The petitioner.
Lord, just to interrupt, subject to Lordship's consent, if the Lordships can direct that the parties can make the ND over without specifying.
No, we are not saying anything. We should not say. We should not. We will just adjourn.
Or suggested as.
We will not say anything. We'll just
Right.
listen to the order and then you make suggestions. The petitioner, a private limited company, had filed writ petition before this court, giving rise to WPC number 19252 of 2010, seeking quashing of an order of termination. Order of termination. Order of cancellation.
Cancellation of allotment.
Cancellation of
Allotment of land.
Of allotment
Of industrial land.
of an industrial land.
and also consequential cancellation of the lease agreement between them.
As well as cancellation of lease agreement.
Lease agreement between IFCO
And the petition.
IFCO and the petitioner. First off, the said writ application aim to be disposed of by a coordinate bench decision of this court dated 24/4/2012. with the following direction in paragraph 8, colon S. Stop. In light of, next, in the light of the directions issued by the coordinate bench dated 24/4/2012, the petitioner said to have given an undertaking to Industrial Development Corporation, Odisha Industrial Development Corporation. Yes. Odisha Industrial Development Corporation to the effect that the terms and conditions of the allotment of land and lease deed shall be meticulously implemented within a reasonable period. Oh, stop. Paragraph 3 उसका है ना 58 का, उसको bold. Stop. In the light of the subsequent to filing of the petitioner's undertaking, comma, in the light of the direction issued by this court in the order dated 24/4/2012, a decision, an order has been passed by the chairman cum managing director IDCO on the petitioner's representation dated 17/5/2012 to the following effect. To the following effect. Paragraph 8 and 9. Para 8, 9 and 10. Full stop. Next. In the meanwhile, the opposite party number 3 herein preferred an SLP before the Supreme Court challenging this court's decision dated 24/4/2012, giving rise to special leave to appeal bracketed C number 18680 of 2012. Stop. By an order dated 21/2/2024, passed by the Supreme Court in special leave to appeal C number 18680 of 2012, comma, where is the stay?
The order dated 13/7/2012.
An order dated
13/7/2012.
Just a minute, we have missed. Do you have a copy?
Yes, madam. Just pass. I've just pencil marked the date, madam.
By an order dated 13/7/2012, passed by the Supreme Court in SLP civil number 18680 of 2012, the operation of the order of this court dated 24/4/2012 has been directed to be stayed. So stop. It is noteworthy that the order which is impugned in the present writ application has been passed in the light of this court's earlier decision dated 24/4/2012 passed in WP number 1919252 of 2010, effect of which has been stayed, operation of which has been stayed by the Supreme Court by order dated 13/7/2022. So stop. Under this writ petition is being heard in the light of the observation made by the Supreme Court in the order dated 21/2/2023 passed in SLP bracketed C number 18680 of 2012. So stop. Now, at your request, we are adjourned.
Yes.
Next.
The request
As
to the bar, your
jointly,
thoughts.
we will not say anything. As jointly requested on behalf of the parties, let the matter be listed on 3 weeks.
Lots of, your losses after can
No.
keep it.
Let us see.
All right.
It will not look proper because the Supreme Court's it is the Supreme Court's observation.
It will be difficult to get this matter.
We will see
listed
then.
there.
We will see. We have understood the entire circumstance. Therefore, we will see on after 3 weeks. If you are not able to get, we will see what can be done.
Yes.
That's right.
What interim order to continue is there.
Interim order is there.
Yes,
Interim order shall continue in the meanwhile.
Deploy.
May I please, Your Lordship?
Just a minute. So when look to WPC 34769 of 2020, the order number 8 dated 17/8/2023. Order number 8 dated 17/8/2023. Out of this batch of cases, WPC 34769. Sorry.
It is on 2 PM.
Yes, item 23, the WPC 34769 of 2020. Order number 8. That is the item 23, that serial page number
34769.
34769, yes. Page 29, yes. Order number 8. dated 17/8/2023. This matter was heard substantially and it is the lead case. That is the order. And though I had given a date chart, I have prepared another chart.
May I interrupt in this? Lead case for matters where my learned esteemed friend is appealing. Not a case for me. Mine read petition is 2029. His case he filed basing up 2019. And his case is thereafter. Therefore, my case is separate. For me, lead case is first, item first. Tarakan Chaudhary.
So let me place my case. You will argue differently. That's my date of events. Let's look. 83/84. All these cases will have the virus of a rule that is granted under 2004 is the subject matter of challenge.
Virus of which rule?
Granted order 2004. So that I have
Granted order.
Granted
2004.
order, yes. 2004. Page 42 that.
In your case, this is not challenge.
I have challenged thereafter 2009. I have challenged 2004 and 2009.
So granted 8/2004 is under challenge in his case.
His case.
In your case, 2004 and 2009 both are.
As because granted order to let's see.
This is the difference between his case and your.
Yeah, let's see.
He is not challenging 2009.
No.
Yes. Just I'm placing my list of dates. 83/84.
26. 2021.
Uh, 83/84. I'm reading my date of events. 3 pages. Madhupur College, where the petitioner were working, Kalan in the district of Jaspur, was established and got concurrence and affiliation from the competent authority for opening of +2 art swings during session 83/84. That is paragraph 3 at page 3. 4/12/2019 and 10/12/2019, the present petitioner was appointed against the first post of lecturer in logic by the then governing body on 4/12/1990, and accordingly, the petitioner submitted his joint report on 10/12/90. Then 1/6/94, the Orissa non-government colleges, junior colleges, and higher secondary schools granted order 94 came into force with effect from 1/6/94, pursuant to section 7C4 of the Orissa Education Act, regulation, payment of grant rate to private educational institution. 95. A proposal was submitted by the governing body to the Director of Higher Education for releasing the grant rate in terms of 94 grant rate order. As the petitioner fully satisfied the criteria of 94 grant rate order, read with section 7C4 of the Orissa Education Act. It is learned that though the proposal was submitted by the college in time, there was delay at the level of the director to release the grant rate in terms of 94 grant rate order. 8/3/96. On 8/3/96, in exercise of the power conferred under section 3B of the Orissa Education Act, read with paragraph 7(5) of the Orissa Non-Government College, Junior College and Higher Secondary Schools Grant Rate Order 94. The petitioner institution, Madhupur College, Kalan, being a category 2 college, as paragraph 4 of the GI order 94, was declared as an aided educational institution with effect from 1/6/94. 19/3/96, in terms of the granted order 1994, approval was accorded to some of the teaching and non-teaching staff of the institution for release of the direct payment of salary cost with effect from 1/6/94. 96. As and when the case of the petitioner was not considered for approval of appointment and release of granting aid in terms of granted order 1994, the petitioner approached this honorable court by filing a writ application bearing OJC number 14057 of 96. That is at paragraph 7. Then 7498, Orissa Education Act 1969 was amended by virtue of the amendment number 5 of 1998, and section 24B was incorporated, thereby conferring power upon the tribunal to adjudicate the dispute relating to or connected with the eligibility, entitlement, payment or non-payment of granting aid. That is section 24B. That was incorporated on 7/4/98. 5/2/2004, while the proposal was pending in terms of granting aid order 1994 before the opposite party number 1, and the matter was pending before this honorable court, the state government, in exercise of power under subsection 4 of section 7C of the Orissa Education Act, promulgated a new granting aid order, namely Orissa Non-Government College, Junior College and Higher Secondary Schools Granting Aid Order 2004. And by virtue of the said order, Rule 4 of 94, granting aid order was repealed, and the granting aid already released under granting order 94 was protected in repeal order. Then 2008, the Orissa Non-Government College, Junior College and Higher Secondary School Granting Order 2008 came into force, and accordingly GI 2004 granting order was repealed. Then 6/6/2009, another granting order, namely Orissa Aided College and Junior College and Higher Secondary School Granting Order 2009 came into force. 23/2/2010, in terms of Orissa Aided College, Junior College and Aided Higher Secondary School Granting Order 2009, the appointment of the petitioner was approved as a lecturer in logic first post with effect from 1/2/2009. Then 9/1/2014, OJC number 14057 of 96, preferred by the present petitioner, was transferred to the State Education Tribunal by this honorable court and was renumbered as a GIA case number 38 of 2014 in view of the enactment of section 24 capital B of the Orissa Education Act, conferring power upon the State Education Tribunal for adjudication of all matters relating to granting aid. Then 1/2/2018, the Land Tribunal, by the order dated 1/2/2018, allowed the GI application preferred by the petitioner by setting aside the order dated 23/2/2010 and further directed the opinion number 1 and 2 to approve the appointment of the petitioner under the granting aid order 1994 and release the granting aid at the rate of 1/3 with effect from 1/6/94, 2/3 with effect from 1/6/95, and full salary cost with effect from 1/6/97. Against the order, the 21/1/2020, against the order dated 1/2/2018, the state government preferred a review petition bearing review petition number so and so before the tribunal, which was also dismissed on 21/1/2020. Para 2020 then, the state government preferred a statutory appeal under section 24C of the Orissa Education Act, bearing FAO number so and so, after a delay of more than 2 years, which is pending. The only plea of the state government in the aforesaid appeal is because of Rule 4 of 2004 granting aid order. The granting aid cannot be dispersed as per the 94 granting aid order. The state heavily relied upon a judgment of this in the case of Anup Kumar Senapati, in which the effect of repeal was discussed. The present writ application was filed challenging the violation of the Rule of 4 of 2004 granting aid order. May I take your lordships to what is the granting aid order? You may kindly look to the Orissa Education Act, because that is substantive. Before I take your lordships to the substance. Orissa Education Act 1969. If you also will look to your Lordship's book, I think page 137. 137. Yes. Section 7C. This was incorporated by your amendment of Act 14 of 1993. The state government shall, within the limits of its economic capacity, set apart a sum of money annually for being given as a grantinate to private educational institutions in the state. 2. No order according permission or approval or recognition under the Act, whether prior to or after the commencement of the Orissa Education Amendment Act 94, shall entitle any private educational institution to receive grantinate. 3. Save as otherwise provided, no private educational institution which has not been recognized by the state government under this Act shall be entitled to receive any aid from the state government. Now we are concerned with 4, 7C4. Notwithstanding anything contained in any law, rule or executive order, or any judgment, decree or order, any court, no grantinate shall be paid, and no payment towards salary cost or any other expenses shall be made to any private educational institution or for any post or to any person employed in any such institution after the commencement of the Orissa Education Amendment Act 1994, except in accordance with an order or rule made under this Act. Grantinate, where admissible under the said rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such date as may be determined by the state government, provided that pending framing of such rule or issue of the order, the state government may, without prejudice to such order, direct the private educational institution which are receiving grantinate and the post in such educational institution respect of which grantinate was being released shall continue to pay such amount as grantinate as was being paid to the immediately prior to commencement of the Orissa Education Amendment Act 1994. Now this section 7C4 was incorporated by Orissa Act 14 of 1993. And at this juncture, may I take your lordship, because pursuant to section 7C4, 94 grantinate order was enacted. That I'll take your lordship, but before that, may I take your lordship to section 24A and 24B, that is at page 159. Any dispute relating to grantinate that will be adjudicated by the tribunal. Page 159. This provision was incorporated by way of amendment in 1998. Adjudication by the tribunal. The tribunal shall have jurisdiction, power and authority to adjudicate all disputes and differences between the managing committee or, as the case may be, the governing body or any private educational institution and any teacher or employee of such institution or the state government or any officer or authority of the said government relating to or connected with the eligibility, entitlement, payment of or non-payment of grantinate. So that will be adjudicated by the tribunal, which is a creature of this Orissa Education Act pursuant to section 24B, and there is a provision of appeal. Any person aggrieved by the order, that is at 24C, that if you also will get it, 24C at page 162. Any person aggrieved by an order of the or decision of the judgment of the tribunal may prefer an appeal before the High Court within a period of 60 days from the date of such order. That is 24C. Now, this is the so far the substantive provision under the Act. Now, you also see, pursuant to section 7C4, with the grantinate order 1994 came into force. Yes. Lordship, kindly come to page 544, 545. Lordship, get it. The Orissa non-government, let's see, 545. The Odisha non-government colleges, junior colleges and higher secondary schools, bracket and granted under 94. In exercise of the power, conferred by subsection 4 of section 7C of the Odisha Education Act 1969, the state government do hereby make the following order to regulate the payment of grantee aid to private educational institution or for any post or to any person employed in such institution, being a non-government college, junior college or higher secondary school as specified hereunder, namely the Orissa non-government college, junior college and higher secondary school granted 94. And if you also will turn to, under this granted order, clause 4 and 5, the category of colleges, and 5 is category of different institution, and clause 9 is the teaching and non-teaching staff of those institutions, how they are eligible to receive grant, that has been categorized. If you also will look to 4, for the purpose of this order, that is at page 547, for the purpose of this order, non-government educational institutions specified in subparagraph 1, 2, 3, and the post in such institutions shall be classified to the following category. Category 1, that means non-government educational institution and approved post in such institution which have received grantee aid from the government or in respect of which grantee aid has been sanctioned by the government prior to commencement of the Amendment Act. Amendment Act means 1993, that act came into force, section 7C4, prior to that act. 2, other posts in non-government educational institution covered under category 1, Roman 1, which were admissible on the basis of the workload and prevalent at stake and had been filled up prior to the commencement of the Amendment Act, but in respect of which no grantee aid had been sanctioned. That means we are coming under the category 2, category 1, Roman 2. That means our colleges have become eligible under this 94 grantee aid order, and they are admissible on the basis of the workload and prevalent at stake and have been filled up prior to the commencement of the Amendment Act. This we have, there is no super, this case is concerned, we are covered under this 4, category 1, Roman 2. Then 5, you also see, look 5, all non-government educational institutions, including in category 1, Roman 1 or para 4, shall be deemed to be aided educational institution for the purpose of this order. Then 2, no non-government educational institution falling under category 2 or category 3, we are category 2 or para 4, shall be eligible to be notified as an aided educational institution under this order unless it has fulfilled the following condition. Condition A, an institution being a non-government educational institution falling within the category 2 has been functioning on regular basis after receiving recognition from the government and affiliation from the concerned university or the council, as the case may be, for 5 years or more, or 3 years more if such educational institution is located in an educational backward district prior to the first day of June 1994. We are coming under this category 2, and this 5 subclause 2 Roman A, capital A, Roman 1. Then so far the staffs are concerned, they are governed under the 9, that is at page 553. So far my post is concerned, that's covered under 9. My college covered under 5, and post is governed under 9. 553, a teaching or a non-teaching post in non-government educational institution coming under category 1, in respect of which grantee aid has been sanctioned at any time prior to the commencement of the Amendment Act shall be deemed to be an approved post for the purpose of this order. We are not concerned because my post has become, my college as well, my post has become eligible after 1/6/1994. Then 2, a teaching or a non-teaching post of subparagraph 1 of this para shall be treated as admissible and shall be eligible for, let's skip over because we are not concerned. Then it's B, capital B, Roman 1. A post in non-government educational institution coming under category 1 for which no grantee has been sanctioned prior to commencement of this Amendment Act, if A, the post was admissible as per the workload and yardstick prevalent prior to the commencement of the Amendment Act, B, has been filled up prior to that date, C, it has completed the qualifying period of 5 years or more, or 3 years or more in case of institution situated in backward district. So far as my college as well as my post is concerned, so far as A, B, C, that has been satisfied. There is no dispute. So therefore, under 94 granted order, the other staff of my college, the college was notified to be an aided college on 94 granted order. So far the staff of other staffs, they have been notified also. They have been approved under 94 granted order. And granted was released in their favor with effect from 1/6/94. So for my case, that means the case of the present petitioner, some reason, some or other, that was not considered, there was some delay. So the petitioner approached this Honorable Court way back in 1996, claiming the granted under 1994 granted order. And while that writ application was pending, this 94 granted order was repealed, which is the subject matter of challenge. That is 2004. But in the meantime, the Substantive Act at 1998, Section 24B was incorporated. If there will be any dispute relating to grant, in connection with grant of any aided college, that will be adjudicated by the Education Tribunal. So this writ application was transferred to the Education Tribunal much after the repeal provision was made in 2004. To the tribunal for adjudication by order of this Honorable Court, that is in 2011. And the
petition,
yes,
you had challenged the virus of 2004.
My.
Still it was transferred.
Still it was transferred. No, but this writ application at that time was not filed. The writ.
This writ petition was not filed.
Yes.
You had filed a writ petition.
Earlier.
You had earlier filed a writ petition in which you had challenged the virus of.
No, I had not challenged the virus. No, I had claimed grantee rate at par with the grantee rate what have been dispersed in favor of other the staffs of the college. After 2000, no, that was filed before 2004. Yes, that is filed. Also look my date chart. That was filed in 96. Yes, that was filed 96. Serial number 7. On 19/3/96, appointment of 19/3/96 also look to just because of
Your case was transferred because
24B, yes, 24B was incorporated on the Orissa Education Act 98. So that will be adjudicated by the Education Tribunal. And the serial number 13, on 9/1/2014, my writ application bearing number 14057 number 96 was transferred. And that was adjudicated in 2018. And it was also in my favor because direction was made to release the granted in favor of the petitioners in terms of the granted order 1994. And in the meantime, several cases, I'll come to that, 237 colleges, they have also approached this Honorable Court because of the inaction in not releasing the grantee net. Those cases were also carried to the Honorable Supreme Court, and the Supreme Court also upheld the judgment of this Honorable Court, and they released the grantee net even after the repeal provision was made under the grantee order 94. That Chittaranjan Das case, I'll place 237 degree colleges and 114 plus 2 colleges. Sorry, 37 plus 2 colleges and 114 degree colleges. All cases after the repeal provision was made, grantee net was directed to be released in terms of 94 granted order, and that was also complied with, and matter was upheld by the Supreme Court. But so far as while this was going on, and several cases, all these cases, mostly the tribunal has allowed the application. But in the meantime, in one of such cases, even in Supreme Court also have enclosed those documents. They have taken the stand which has been turned down by the state has taken the stand that repeal provision has been there. Still then the Supreme Court has passed order. They have complied with that order by extending the benefit on 94 granted order. In one Anup Senapati's case, this problem came because of this. This court is honorable single judge here said that because it has been repealed, that 2004 94 granted order has been repealed. Repeal means that will be given effect to with effect from the date when the 94 granted order came into force. That means it has no existence with effect from 1/6/1994. That means 94 granted order is no more in force, at least with effect from 1/6/94 because of clause 4 of the repeal provisions of 2004. That in fact was carried to the Honorable Supreme Court. Supreme Court upheld that judgment by that is Anup Kumar Senapati's case. That was a case where the repeal provision was not challenged, where it was said because of the repeal provision of 2004 granted order, 94 is no more in existence, and that is no more in existence in view of the law of the land, that with effect of the date when it came into force. That means with effect from 1/6/94. That is what the thereafter will not in almost all cases the state took this stand that because of that Anup Senapati's judgment, so you are not all these institutions, even if they have been governed under the 94 granted order, they have satisfied the requirement in terms of 94 granted order, and the staff of most or other staff have been allowed to receive the granted 1994 granted order. You will not extend that benefit. In fact, they have taken that stand in the appeal which they have filed before this honorable court is pending. So now before Lordship, the question for consideration is the repeal provision of 2004. In fact, 94 has been repealed. 2004 has been repealed in 2008. 2008 has been repealed in 2009. But because of repeal, this 94, all the benefit which has been extended after 2004 to large number of colleges, institutions in terms of 94, there is a discrimination so far the petitioners are concerned. That I try to address your Lordship, those judgment I have brought. So today I don't think because an advocate general is not there. So if your Lordship will keep to some other day, at least I will take half an hour to only on the question of law. This is the entire background of the my learned friend. Yes, see.
Let my learned friend finish, then I'll.
You wanted to begin.
And Mr. Rafi also appearing in some
cases. In some cases, I am also appearing. I'll assist my lords on the proposition of.
Let us see where is that.
Yes, yes. No, I'll place that. That's the big judgment. I'll place. In the counter, they have enclosed that copy of the judgment.
Number 7.
Then only by the exception.
Just because the proposal user charge for a CC there also there is no right for them. As we
Please, it's proposal
96
Granted order of
94.
94 was repealed in 2004 under Rule 4, Repeal Provision 4. Yes.
Yes, Section 6, General Clause Act and other provisions have been gone into by the Honorable Supreme Court. The scope of consideration was after repeal of 94 in 2004, whether the persons can claim benefit of 94 granted order after repealing Act came into force.
Supreme Court says no.
No.
Because that is not
clear.
safe.
Supreme Court in clear words, with loud and clear words have said, no, they are not permissible because no vested right has accrued.
Supreme Court further says that those who claim benefits under 1994
right,
within a reasonable period,
yes,
only they could have been granted.
Yes, yes.
That's right.
There
are two things, Lord. Now, we will just try to convince my lords whether we are coming within those category or not, number one. Number two, The question of whether repealing act is constitutional or unconstitutional, that was not the scope of consideration before them.
That we can consider.
That is not a challenge here. But if your lordship says we are
See the terms of.
I consider it.
Terms of.
Supreme Court judgment even after Anup Senapati's case.
Yes.
Each copy. Yes.
Order 1994, it is hereby repealed, save for the purposes mentioned in subpara 1 of paragraph 3.
As your lordship pointed out, saving clause, that also a discrimination.
Yes.
Because they have saved those who have already got it, received it, but they have not saved. So far, those are
Admissibility of granting aid,
yes.
that is only saved.
Those who have
Received.
3.1 is only saved. That is what the
Yes.
repeal. So repeal destroys the earlier one.
Yes.
That is Hindustan Constitution.
Yes.
That is Hindustan.
Supreme Court.
That is Hindustan Constitution. But we will try to draw an issue of distinction, discrimination, saying that
We cannot go into, because the provisions have been read by the Supreme Court and interpreted by the Supreme Court.
But the question, of course, I was not clear. The clause 4 of the granted order 2004 was not the subject matter of challenge. Rather, it was relied upon 4 because that was a case where the proposal was submitted after the 2004 granted order came into force.
Repeal and saving, that is the
That was a case. You'll also kindly have a glance. They received 2004, they claimed, yes,
and in those cases where rights have not accrued.
not accrued.
Could that be challenged?
Let's see, may I place something? Let's see.
Yes.
Let's see, may I place something?
This clause.
2004, let's see.
Ticket.
2004 granted order. Tell
Anyway,
what you want.
My lord was saying something.
No,
You're not.
it's all right here.
So, Lordship, 2004 GIA order was never implemented by the state. We have not received GIA under 2004. We have been received under 2009. Now, Lordship, law settled in proper South Supreme Court was pleased to reject the claim of the state. And it is in 2010. When 2009 the granting order was in force. Now, after the dismissal of the Supreme Court of the state appeal, they release in favor of the many employees under GI order 94. Now, in a belated stage, they are saying you are.
Section 7C. The policy of granting aid
Yes, sir.
is in the background of section 7.
Right.
Correct.
Section 7C does not say that granting aid shall be.
No.
Subject.
7C says whatever granted from that date it will be paid, that is in terms of the provision to be made in terms of section 7C4.
No. But the first section 1 is most relevant.
Yes, sir. Within the economic capacity.
Economic capacity.
Take apart a sum
Yes, sir.
of money annually
Right, sir.
for being given as granted.
Yes, sir.
So if someone demands that he wants granted aid, then the state government is accordingly required to set aside some money for that. That cannot be dictated.
With your lordship's kind permission. This particular section 7C1 was the subject matter of challenge in a batch of writ application which has been disposed of by this honorable court, by a coordinate bench of this honorable court, which was tested before the Supreme. That is a case of Prafulla Kumar Sahu. As your lordship rightly pointed out, that the sum of money set apart annually, that has been interpreted to the extent that it is a duty of the state government once you make this, because earlier to this provision, there was executive instruction. But this was made by legislation. So it is the duty of the state government, that judgment I have given to your lordships, to set up a particular sum of money for the purpose of release of the grant. Suppose this year it is not possible, they can make it next year. But they cannot say that other than the provision which is made under section 7C1 or 7C14, that they cannot go beyond that.
course, to my understanding,
Yes, sir.
the interpretation of this provision is
Yes.
that the government has to assess
Yes. If your lordship,
the budget against this head. How much?
but that is a,
And therefore, depending upon the demand, the requirement.
yes, yes.
The
Government has to
Right.
Government has to set apart.
So what
Government has to set apart.
And this is confined to institutions.
Institutions.
Not employees.
employees, na? So far as the 7.1 is,
Looking to the strength of the employees, but it is to be given to the institution.
so far as the 7.1 is concerned, as rightly my lordship pointed out, that is institution. But 7C4, that is both institution and the post. Let's look to that. Because
Or
that has
for
been-
any post.
Yes. And that judgment, if I
Or to any person.
Yes. And accordingly, 94, Rule 5 I've just placed before lordship, that is in respect of institution. 9 is in respect of the post. No, I'll definitely, I'll try to at least persuade your lordship by those judgment. Exactly this section 7C1 was the subject matter. What was the finding? बाहर कर दो दे दो सर इधर क्वेश्चन
No, but again, subsection 4 does not refer to payment to an employee. The purpose.
What's the purpose, sir? Your lordship is right. Purpose. But
The grant is to be made in favor of the institution, not for the purpose of what is there in subsection 4.
that is qualified with further that a rule or order or provision has to be made in terms of section 734.
It is not saying anything contained in law.
In law.
Rule so and so any judgment or degree.
Yeah.
Decree no grant in aid
Shall be paid and no payment to salary cost. Salary cost.
No payment. This no payment is not by the government to the person.
Then you also say accept.
Six the institution.
You also then proceed.
Payment for salary cost or any other expense shall be made to any private education institution for any post to any person.
Yes.
Post to any person or to any person employed in any such institution after commencement of.
Accepts it. Except in accordance with the
So
order.
the grant is to be in favor of the institution, not to an individual.
No, sir, this is
no. Qualifies no.
No. But why no? Except in accordance with an order, a rule made under this act. That is important.
Provided that the grant itself be made to the person.
Yes. You also again look to that. I just tell you. 94. You also page 545. 545. The 94 is 7C4. 545. Let's see the preamble. This is in terms of subsection 4 of section 7C. You also get it. In exercise power conferred by subsection 4 of section 7C of the Orissa Education Act, this was done. And you also read, the state government do hereby make the following order to regulate payment of grant in it to private education institution or for any post or to any person employed in such institution, being non-government college, junior college, and so on. Then you also turn to para 9. So far as the person is concerned. Post is 5, order number 9. Order 5 is post. You also look to that post. all non-government educational institution included in category 114 shall be deemed to be aided educational institution for the purpose of the order. 2. No non-government educational institution falling under within the category 2 of category 3 of para 4 shall be eligible to be notified as an aided educational institution under this order unless it has fulfilled the following conditions. That means institution, if they qualify and fulfill the conditions, then that will be notified to under the 94 grant rate order. And so far the post is concerned, so let's come to page 553, 9. I will just clarify to your lordships because prior to this 1694, when this 94 grant rate order came into force, in fact, the grantinate was released. There is no problem for releasing the grant, but that was by virtue of the executive instructions. There are no statutory rules. For the first time, when this section 7C was incorporated, 1993, they thought of for grant to release the grantinate in terms of the grantinate order, in terms of the statutory provisions. That is how, in terms of section 7C4, this 94 grantinate order was formulated. Yes. If your lordship will come to page 553, para 8 and 9. Para 8 and posts. Yes. In married blood. In para 8. Yes. A non-government educational institution which has been notified as an aided educational institution shall not ipso facto be eligible to receive grantinate. Such an institution will only be eligible to receive grantinate towards salary cost of teaching and non-teaching post in that institution which are eligible to receive grantinate in accordance with the provision of this order. Then 9. A teaching or non-teaching post in a non-government educational institutions coming under category 1 in respect of which grantinate has been sanctioned at any time prior to the commencement of the Amendment Act shall be deemed to be an approved post for the purpose of this order. Those institutions have already been notified. Those are coming under clause 1. Then, sir, 2. A teaching or non-teaching post not covered by subparagraph 1 of this para shall be treated as admissible and shall be eligible for approval subject to satisfying the following condition. A. The post in respect of which approval is sought is the post is in an educational institution which has been notified as an aided educational institution. B. A post in a non-government educational institution coming under category 1 for which no grantinate has been sanctioned prior to the commencement of the Amendment Act if A. The post was admissible as per the workload and at stake prevalent prior to the commencement of the Amendment Act. B. Has been filled up prior to that date. And C. It has completed the qualifying period of 5 years or more or 3 years or more in case of institution. Sure.
According to the administration of the government, granting aid is to be given against the post for employees to the institution.
Right. Absolute rights. Absolutely right. Yes, correct.
Sir, correct.
Absolutely correct.
That is the proposition.
And any person cannot.
No. It's only.
It is only post. It is only post.
No question of any
Sir,
person.
that person is this.
Person is holding a post.
Right? No, it is only for a post. That's right.
Post.
A person holding post, even he cannot claim grant.
Yes, sir, that is there. That who will be? There is a prescribed adstick. Adstick means that for a particular college, degree college, having road strength of this, they have made a adstick. Sir.
We understand. The question is that if there is an institution.
Yes.
Which has employees.
Yes.
The institution has.
Sir.
Institutions are not claiming that they are entitled for grant. Are they have to come?
No.
So in some cases, institutions have come, some cases staff have come.
Notified and added.
But so far as your lordship's query is concerned, that is there. That I'll show your lordship that even the persons holding that post is entitled to receive the granting aid in terms of this granting aid order, that is one. Yes, yes.
Because the granting aid is released to the institutions for that person.
But that, sir, it is both. It is a composition of both. A person must be eligible to hold that post, and he must have completed this requisite period of service, 3 years, 5 years, or 7 years. Then he is eligible to receive entitled to receive the granting aid. That is what the
question is whether the institution is entitled.
Sir,
Can an employee?
Yes, employee. That right is. Yes, sir.
That his institution is entitled to.
Yes, that is yes. That
The institution is not raising such claim.
no. The employees, they have a right under this 94 granted order, and so that provisions. Once they satisfy the requirement of the 94 granted order, it will be released under direct payment to the person concerned. Now, this was, I think, in Patna, I don't know what was there. Here, what has happened? Here, prior to 1993, there was a direct payment. There was prior to 74. In fact, in 1475, the new rule came into force. There was a provision that salary cost was being.
Of Supreme Court.
In these cases, I'll give to your lordships directly to these persons. No, quite
In one of the cases,
sir,
I had heard
sir,
that when the institution has not come for claiming grant in it, employees cannot maintain because it is the relationship between employee and the employer. So if the employer is not, he can have grievance against his employer, not against the government, because he was employed by this view has been set aside by Supreme Court. You can find that.
But here is a case, just in Odisha, the provision has been made under the rule that is a direct payment system. It will not be through the institutions. It is open mind.
That decision is by, if I remember correctly.
I will find out. We'll find out, sir. We'll find out, sir.
Wherein that if not the employees cannot come, employees cannot approach the court, then who else? Because they are the.
No, here is a little bit different. Here, yes, you are saying right. Absolutely. I don't know there. What is here is a direct payment system. Direct payment system means they are trying to exploit this in management. They are trying to exploit the salary of the teachers. So therefore, the state government made a provision that will be paid by way of direct payment to the directly salary cost to the account of the teachers. That is there.
Yes. So what do you?
2009. 2009, what they have done, those staffs, those are left out to receive the grant order 1994 after the 2004 block grant. That is a block grant. That is not a regular grant. 2004. In 2009, they said that they will only receive the block grant. Even the persons have satisfied the requirement and satisfied the eligibility criteria of 94, they are only entitled to receive the block grant. They are fixed sum. So that is the he challenged. We are in fact we have received the salary. In fact, if your lordship will say that 2000, because in my case in 96 I have come to the court, and my proposal has been submitted much prior to 2004, and my other staff have already been approved on 94 who have been appointed subsequent to me. So only the question is matter was pending before the judicial forum. And the matter was pending here. Subsequently, that was transferred to Tribunal, and Tribunal, in exercise the power under Section 24B, has decided in my favor. And in similar cases, where Tribunal has adjudicated the matter after the repeal provision was made, that has been upheld by the Supreme Court, and Supreme Court, after upholding the order, that has been extended the benefit of 94 granted order much after 2000. Yes, I've given to your lordship's judgment. I think sweet. That is High Court judgment is OJC 126 of 2001. I've given that. Yes. A lot of litigation. Lot of litigation. In fact, I find if your lordship will at least consume some time, at least your lordship know that most of the litigations are confined to this.
State.
Yes. This court. And this has been upheld by the Supreme Court in 2011.
That is also there.
That is also there.
We have given it.
But my lord was referring to that, to popular counsel. Yes, if the lordship will come to that judgment, incidental. Just I'm reading what is the claim in that case. The case of the petitioner stated in the writ application is that he was appointed as a library attendant also by the governing body of Kunjaber College, Barang in the district of Kurda, which is an educational aided institution aided by the government of Orissa. Pursuant to the said appointment, he joined as librarian such and such date and worked as library attendant. His appointment as library attendant was also approved by the Director of Higher Education, and grantinate was released in his favor with effect from 1691. By resolution of the governing body of the State College, adopted 5696, the petitioner was promoted to post of non-graduate librarian with effect from 1687 in the vacancy of so-and-so, who was promoted to the post of graduate librarian with effect from 1687. The case of the petitioner for appointment and promotion to the post of junior librarian was sent to the Director of Higher Education and thereafter to the state government for approval. Since no decision was taken by the authority, the petitioner filed a writ application bearing OJC number so-and-so before this court, which was disposed of by order dated so-and-so of this court, with an observation that the authority will deal with the matter expeditiously, preferably within a period of 6 months from the date of receipt of the order of the court. Pursuant to the said order dated 10/11/97 of this court, the case of the petitioner was considered and rejected by the Director of Higher Education by order dated 21/10/98 on the ground that the post of junior librarian cannot be filled up by a promotion. The petitioner then submitted a representation to the state government with a copy to the Director of Higher Education. The Director of Higher Education then, in his letter dated 19/5/99, moved the state government for reconsideration of the case of petitioner for approval of his appointment to the post of junior librarian with effect from 1687 and for release of the grantinate in his favor of the petitioner in the post of junior librarian with effect from 1692. Since no decision was taken by the state government on the said representation of the petitioner and the recommendation of the Director of Higher Education Orissa, the petitioner filed another writ application bearing OJC number 498 of 2000 before this court, and the writ petition was disposed of with a direction to the state government to consider the said representation if pending within 6 months from the date of receipt of the order. Pursuant to said direction, this court in the order dated 17/1/2000 in OJC number so-and-so, the state government has considered the proposal for approval of the appointment of the petitioner against the post of junior librarian and has rejected the same by order dated 9/8/2000, which is quoted below. Quotation, if you also see the reason of rejection, first paragraph. In pursuance of the Honorable High Court, so-and-so, I am directed to say that government, after careful consideration, pleased to decide as follows. 1. In view of the government decision to abolish 50% of the base level post and Finance Department circular restricting filling of vacant post, a decision was taken not to admit any post in the cadre of Class 3, Class 4 post into the grantinate pool unless it is considered essential for the academic session, so-and-so. Then you also skip over. Then agreed by such decisions, so and so, so on. Yes. That also I'm taking to lordship's paragraph. Paragraph 14, 15, yes. Paragraph 14 upwards. In so and so case, the Supreme Court has rejected the contents of Chandigarh administrative that it was difficult to bear the financial burden towards granting it. The Supreme Court held in Batter coming to the contention of the appellant that the Chandigarh administration will find it difficult to bear the additional financial burden if the claim of the respondent number 1 to 12 is accepted. We need only to say that such a contention raised in different cases of similar nature has been rejected by this court. The state administration cannot shirk its responsibility of ensuring proper education in school and colleges on the plea of lack of resources. It is for the authorities running the administration to find out the ways and means of securing funds for the purpose. Orissa is a state with large section of people, including scheduled castes and scheduled tribes, who are illiterate and backwards, consistent with the directive principle of the state policy in Article 41, 45, and 46 of the Constitution. The legislature has imposed a mandate on the state government under subsection 1 of section 7C of the Orissa Education Act to set apart a sum of money annually for being given as granting aid to private educational institutions in the state, subject to the limits of its economic capacity. The state government has also made the granting aid order 94 under subsection 4 of section 7C of the Orissa Education Act, clearly indicating the relevant factors to be taken into consideration for deciding the eligibility of an educational institution or a member of a teaching or non-teaching staff of such educational institution, keeping in mind the educational needs of the state. The state government cannot ignore such legislative mandate, as well as the directive principle of the state policy and the statutory provision of the Granting Order 94, unless therefore there are other more pressing needs than education. The state government must set apart sufficient money for making payment of granting aid to educational institutions of their teaching or non-teaching staff in accordance with Granting Order 94. 16. For the aforesaid reasons, the impugned order dated 9/8/2000 is quashed, and the Director of Higher Education and Secretary of Higher Education, Government of Orissa, are directed to reconsider the case of the petitioner for approval in the post of junior librarian and eligibility or admissibility of granting aid strictly in accordance with the Granting Order 94 and the observation of the judgment within a period of 4 months from today. If such approval is granted and the petitioner is declared to be eligible to be granted aid, the state government will issue an order specifying the date for payment of such granting aid after arranging the resources for the same in the budget for the next financial year. With the aforesaid direction, the writ petition is allowed, but considering facts and so on. So this was challenged, and in 2006, after this 2010, on 18th August 2010, that I have enclosed along with my writ petition at page 56. This was disposed of by this Honorable Appeals Court on 18th August 2010, much after 2004 repeal provision was made. And by that time also the 2004 has been repealed in 2008 and 2008 has been repealed in 2009. In 2010, judgment was passed. We have carefully gone through the impugned judgment passed by the division bench, and the question which was raised by the state government before the Honorable Apex Court, even in a review petition, that because of the repeal provision, this section clause 4 of 2004, that they are not entitled to. But the Supreme Court upheld the judgment of this court, and this judgment was implemented in respect of 114 colleges, degree colleges in the state, and 41 plus 2 colleges of the state. And following this judgment, I have given that judgment also, Chittaranjan Mahapatra case on 12/1/2011. That is in my bunch of that judgment I have given. That is at 12/1/2011, and the number of the colleges also have been clearly mentioned in the judgment itself. How many colleges have got it? That is at page 2.
The full has been taken notice by Supreme Court.
No. So far as the Populous House case.
Profula was of...
No. Somehow it has not been.
No, that is relative to granting aid.
That is relative to Populous House case was to
granting aid of 94.
94? That is 94.
So this court annexer A by 1 counter affidavit filed on behalf of party number 1. They have enclosed division bench decision.
No, that is a judgment that I'll say.
Paragraph 52 and just
you
just come to that. In this context, the court likes to observe that any number of orders that may have been passed by the learned single judges of this court in individual cases granting benefit to certain other educational institutions of the Granting Aid Order 1994, even after its repeal, cannot be considered good law after the decision of Supreme Court in Anupsana.
This judgment which has been enclosed, that was arising out of a contempt application.
Yes.
That was arising out of a contempt application. And there is.
But a finding is that in the contempt application, since at the time of rendering those judgments,
that has not.
Anupsanapati was not there. So in the contempt, the lordships
The lordship have referred to that Anup Senapati case. But so for the Prafulla House case, nowhere it has been considered. Nowhere. And the repeal provision, nowhere it has been considered. And the Anup Senapati's case was a case where the proposal was submitted subsequent to the repeal provision was made in 2004. No. Only relying upon the repeal. Relied upon the repeal.
Repeal was never challenged.
Repeal was not the challenge. Yes. Yes.
But the repeal has been.
Therefore, yes. The entire case was on the basis of the repeal.
Repeal only, yes.
The entire case was on the basis of the repeal.
So if the board has provision to be ultra virus, this what will happen to this Anup?
But so far as Anup, if I'll show your lordship the judgment of the even orders passed by the Honorable Apex Court after Anup Senapati's case, they have extended the benefit of 94. So sir, I am sure that I'll.
This division is elaborately discussed. And finally, after that paragraph 52 and 55 on the issue that benefit even under granted order 2004 could not have been granted in 2017 after it was repealed in 2009. It must be noted that in Anup Senapati, the Supreme Court took note of the fact in the granted order 2008, there is a repeal and saving clause which reads as thereafter, therefore, the court finds no merit in the contention. So they have said that all this.
Yes, sir.
If we hold that,
But,
then what will happen to this?
But in that case, my respectful submission is that the Honorable Apex Court considered the effect of repeal. Effect of repeal. Your lordship, if suppose your lordship will declare that repeal provisions leads to discrimination or whatever it may be, then the judgment may be ineffective. But the question whether your lordships have, you lordship can exercise the power of Article 2. No, we'll try to find out also. We'll also find out.
This judgment has not been challenged.
But that judgment?
This, no,
the contempt judgment.
A by 1. The annexer A by 1.
No, that Jasamant Baral's case. That instruction. I'll take instruction. I cannot say because I was appearing in the content matter for the Jasamant Bara, but I don't know what has happened there. That is arranging out of content.
Make submission.
Can we hear him now? Yes. You see, you have 10 minutes.
Lordships, may I please, lordships. My first contention before lordship is this 94 granted order came into force by virtue of the statement of object to bring.
No, so far 2000 up to 2004 order. Submissions have already been made. So you have to add anything beyond what has been submitted in respect of 2004 order, the matter is different. Otherwise, if you have to add, you have to refer to 2009 order, and find your submission. You may adopt those submissions.
Lordship, what I am submitting, lordship, those 2004, why I have challenged the virus of this act, lordship, 2004 order and 2009 order are an executive instruction. Both are an executive instruction. Lordship, why I am telling this is executive instruction. The law provides under under section 25 that any order passed by the authority is subject matter of the control of the section 25. Lordship has to be laid before the legislature. Section 25 says. And the RTI report says the executive instruction was not laid before the legislature. To the extent, lordship, I wanted to bring my lord's knowledge.
94 was there.
94 was laid. This is RTI report, lordship, laying down Laying down will not invalidate the law.
Lordship,
That is already settled.
to the extent what I am submitting, Lordships, that cannot, this executive instruction cannot override the right granted under the Act, Lordship. Act 94 Grantinate Order stipulates for receiving GIA in favor of the employees who, in view of the fact that if college is recognized and come under the purview of section 3B of the GI order. Oh, let's see, this virus I have challenged. What my the
Order. So we are taking up only such cases which are in statutory.
what I am submitting, let's say, is statutorily bad by the Odisha, under the Odisha Education Act. Lordship. Lordship. That may be decided, Lordship, because executive instruction cannot make invalid the law of the Odisha Education Act, Lordship.
Anything else?
Then Lordship, in that executive instruction, 2009 order, Lordship, they say the employee shall be entitled to get the benefit from 1st January 2009, curtailing all the continuous of service benefit, Lordship. Therefore, I am on the point, Lordship, my right has been vitiated, Lordship. It's accrued right under 94 GIA order, which says a qualification for the prescribed GIA is for 5 years. In an incumbent will get the benefit under GIA, Lordship, after completion of the 5 years of tenure. Now, in view of the Granting Order 1994, this was implemented. Now 2009, 4 and 9, they said, from the date this act came, Lordship, kindly come to that provision of 2009, Lordship. Very interesting, Lordship, how executive instruction has overtaken the legislative intent, Lordships. This is at page 399, Lordships. Payment of block grant under the Odisha order shall be made with effect from February 2009. No claim on account of block grant under this order shall be made or entertained for any period prior to the month of February 2009. Now let's see, we have joined in the year 2000, 2095, 96, 98, 97. Let's see, now we will not get benefit under this act order. Now they are curtailing benefit for 20 years, Lordships, salary benefit. Now I am heavily relying the judgment, Lordships, of the, I have got all the judgments, Lordships. Because, Lordship, in this Profulla Sahu case, what I am submitting, Profulla Sahu case, I had the occasion to argue before the Honorable Supreme Court, that Profulla Sahu case. The state government has never come. On 2010, when it was taken up for hearing, government only say, since we have to pay 100 crores more, therefore we are not in a position. Their Lordship said, you are bound to provide amenity for the lecturers and the institution.
So when did the Supreme Court say?
In that aspect, Lordship, Profulla Sahu case, they did not come with the counter that 2009
we have come with the 2009 granting aid order. Now, after the dismissal of the SLP, they have implemented to Profula South case. Till now, they are implementing. I have filed the annexures. Now, in a belated stage, they are denying us by saying you are coming under the provision of 2009, which is an executive instruction, Lordship. Lordship, for that purpose, I have given the judgments.
Take up your matter. Then, can we take up this matter to this matter tomorrow?
Tomorrow at 3 o'clock, your lordship have, and tomorrow, your lordship, at 3 o'clock, your lordship, I think reference. So next week, Wednesday, next week, the list, let it in the list.
My learned friends matters, since he has additional points, are they fine? And those matters segregated and our matters.
My small prayer, my lord. My small prayer. Item 65 can be taken up tomorrow, my lord.
We can pick up your matter tomorrow. It will be there. What is your issue?
What is my lord? The issue is already settled by the Honorable Supreme Court, my lord.
Monday.
Either Friday or
Item number 6.
My case is Monday, my lord.
Item number 6, your lordship.
just item number 6.
Thus here, as of by at about 4 p.m., 22 persons have been paid to their account, Lord. Because of this slow, the server is down. I've got only 4 persons details which have been credited to the account. I've given to my friend.
My lord, I have not a single person has received the payment. They are saying the server is down.
Your lordship, kindly look at it.
Right. If your statement is found to be false,
My lord.
then we will initiate contempt proceeding against your.
My lord, till
How many persons are there?
4 persons I've given your lordship. Now the case is not a single. 4 persons details I've given to whose their account it has been credited.
Against your friend.
My lord, this is the state.
We will initiate contempt proceeding against your client for misleading the court. If this is your submission that no person has received the amount, he is saying that 4 of them have received. Your instruction is that none of them have received. You will initiate contempt proceeding against your client.
My lord. No. I have checked. They have said.
Sorry, this is your instruction that they have not received.
They have not.
Misleading you.
My lord, that has not been credited to their account. They have said nothing has been credited to our account.
Why it has not been credited?
Your lordship, Kuber, the amount has been approved. Your lordship, this is the statement of the bank so treasury.
Monday, my lord.
No problem, bhai.
We'll take up on Monday.
My lord.
Other matters, Other matters.
Item will be listed either on Friday or further.
Monday,
Monday.
Item 34, you learn it Monday. Item 34.
Pardon, Lordship.
Monday. Who is in 69?
My lord, I'm pretty sure. It's a covered actually your lordship's order. I'm also giving copy to my friend.
The other side.
Same order is to be
Other side?
passed. A lordship's order actually. These items in list is at serial number 3 of that list. 3703. Mine is identical at the
160.
last one is mine.
This is 168A.
My lord.
168A.
My lord.
GST.
My item is the last
The
one.
period of limitation by
Yes,
which
that's the issue, my lord.
CBSE, sir.
Your Lordship, actually under 168A, the time has been extended with the permission of the guidance of council.
My case is actually
Without that
8483.
measure. You have invoked the force measure after COVID.
But this order is to.
I have already filed counter. In some of the cases, I have already filed counter on behalf of the state GST. And also the petitioner has filed the rejoinder, Your Lordship. Your Lordship, in all these cases, in some of the cases, Your Lordship, the assessment orders have been challenged. And in some of the orders, focus notice have been challenged, and Your Lordship has passed these orders against the focus.
It's still pending at serial number 3 of that batch, my lord, at 69. 69. And mine is actually last one, 8483. This order is to be passed on 8483. Notices.
We will tag to this.
But yesterday it was there, therefore your lordship have tagged. But in my matter, no, a notice has not been issued. The same order is to be passed. 8483 is the last one, my lord.
So my lordship, kindly remember. Your lordship, kindly remember the other day, my lords directed Mr. Pari to remain present in the court. Mr. Pari here, in fact, now also. Union of India.
Sorry, my lord. Yes,
This 168A section has been inserted by Parliament as well as that has been adopted in the state GST during COVID to mitigate the hardship, right? So pursuant to that, ordinance was passed. Thereafter, Act has come. So 168A only confines to force measure. Then the period of limitation could be extended.
Extended, yes.
Separate act under Income Tax Act also, separate
119.
and separate act was also promulgated. So here, after the force measure pandemic situation is over, this provision has been invoked. That is the challenge, I think.
Let my friend file a counter because all have filed that.
You are representing GST Council.
No.
Who is representing GST Council?
I don't have any instruction, my lord. We have written letter to the GST Council as well as the ministry. We are not getting any instruction or any response from them. All right. Then you want us to decide, you decide.
Your lordship, so far as the Central GST Commission and CBSE is concerned, I have filed 2 counter, my lord. I have already filed counter.
No, you are representing GST Council.
No, I am appearing for CBSE and the Commissioner.
Commissioner.
CBSE and both. And CBSE has the notification basing on the 168A. So
you are defending the notification issued by the CBSE.
CBS.
Well,
I think in the last occasion, my friend Mr. Satpathy said you have instruction to file on behalf of the.
No, yes. But sometime on special instruction from the GST Council, we are appearing, or sometime Government of India, BSE are appearing. I think that has not
been. Letter, I am expecting that something will get to within next week. 1 week after last week. Otherwise, we will be deciding, and that will not actually good for you. I will convey this lordships. Yes. You should not convey us. Naturally. You are taking it only tentative. You should. Council is not deserved. So
Council has a great role because on their recommendation only Government of India has issued this notification. They are the main lords, sir. Yes, sir. Interim to continue all cases.
I'm only on one matter, 8489, 8483.
Let's be reflected.
My case number is 8483. It's the last one. It's the last one. No.
The last one, the order has not been passed. In this matter, my learning senior says that in this matter, this interim order may be passed and this may be tagged.
Lordship may reflect in the order itself about the instruction of the GST Council and the Lordship may reflect the ordership. That my prayer will be Lordship may reflect about the response from the GST Council and the Ministry in this proper adjudication case. It will be help me in this regard.
You are one of the parties there.
Yes, yes, we have the party, that's why.
It is helpful if
Parties
your
they have
lordship observe that, it will
they
help
have-
us to get the instruction.